Look, are they here? Go ahead, the rest of them taking that. Oh, I don't. Work on the paper. They're concerned. You got the warrants? I'm saying, I'm sure it's different here. What it's like, right over. So many people here, you got warrants on. No, that's very good. We have that's its face. Yes. The rest of them on the warrants and holds that day. We politics, we're playing out on the country game basis. Just call him, but what's the name? James Abson, would you come forward, please? Mr. Abson, come right over here. They've got they want to talk to you back there. They want to talk to you. Who else that we got?
It's Maggie Scott.
Maggie Scott. Maggie Scott. Are they your clients?
Miss Scott's, Mr. Cross is Mr. Abson's mine, so
let me tell you what's going on. We're just gonna serve those warrants on them, keep them back, do their business here, and they can talk about making a bond on those cases over there, okay?
yes, Your Honor.
Daniel Morland.
Judge, I've got some paperwork printed on Mr. Morland. We've already went over it, but as soon as he gets printed, we can do his plea. It was, Mr. York was printed over across the hall, so. But we've already run over forms on my laptop, Judge.
Get Mr. Moore, that chair that's over there, sit it right over here. So Mr. Moore, can sit down, let you sit down while you can. All right. Aaron Southworth. Commonwealth versus Aaron Southworth, 24 CR 0040 for a pretrial conference and 22 CR 0072 for a pretrial diversion revocation. You are Aaron Southworth?
Yes, sir.
You born in 1992? Last four digits, social security number 7202. What do we have here?
Your Honor, we have a felony plea.
Mr. Southworth, the motion has been tendered. It says you wish to hear the plea today. Is that correct? Let him behind the microphone there. I know you like the spotlight. Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that we just identified in 24 CR 0040 and 22 CR 0072?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney and you feel like you're fully informed?
Yes, sir.
Are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you and you believe you fully understand?
Yes, sir.
You understand you don't have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make the same thing. The right to a speedy trial by jury. You have to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. The right to pull this matter to higher court if you lose. And the right to require the Commonwealth to prove it on a reasonable doubt that you get the charges. You understand about entering this plea today, you give up those rights. You understand that?
Yes.
Now, I may consider the Commonwealth's recommendation by Matt may apply any range of a lot of them have to accept the recommendation. Now, are we gonna have a pre-sentence investigation report done?
Yes, sir, where it's avoided.
Okay,
Yes.
Prior to accepting any recommendation, I'll wait till the precinct's investigation report, probation and parole. When I bring you back for sentence, in the event that I don't accept their recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and go to trial. You understand that? So as much as I can give you is what you can read. Now, what is, if y'all stand to your left there, what is the Commonwealth's recommendation, Ms. Anne Marie Gordon Anderson?
Yes, Your Honor. Upon a plea of guilty to burglary second degree, the defendant shall receive a sentence of 6 years to serve. The defendant shall have the 5 following guns submitted to the Monroe County Sheriff's Office no later than Monday, August the 5th of 2024 by 4 p.m. It's a .308 caliber Colt Action BB Arms co-brand of Morland or Remington rifle with unknown serial number, a 12 gauge pump Winchester shotgun having wild cherry stock, release trigger with serial number 1927172, 12 gauge, 12 millimeter full synthetic automatic Mossberg Sun shotgun with an unknown serial number, 12 caliber automatic Woodstock Marlin Firearms Co. rifle with unknown serial number, and a 22 caliber single action Woodstock Marlin Firearms Co. rifle with an unknown serial number. All guns shall be in good condition, and the defendant shall stipulate to revocation on Monroe indictment number 22 CR 72. Thus, the 6-year sentence shall run concurrently with Monroe indictment number 22 CR 72 and run concurrently with the Allen County indictment number 22 CR 271. The Commonwealth opposes probation and shock probation. The defendant shall pay restitution in the amount of $2,750 plus 5% clerk's fee as regards to the missing MFD contender muzzleloader by Thompson Center and costs to refurbish remaining guns at a monthly rate of $150 per month, with first payment being due to the Monroe Circuit Court Clerk's Office within 60 days of being released from incarceration. The 5% clerk's fee shall be in addition to the monthly payment of $150. The defendant agrees to have any and all evidence destroyed in a manner that is consistent with the laws of the Commonwealth and the holding agency.
Is that what you agreed to?
Yes, sir.
Are you pleading guilty because you didn't commit the acts charged in the indictment as a
Yes, sir.
Are you doing so of your own free will?
Yes, sir.
Knowing your constitutional rights, is it still your desire to waive them, enter a plea, and allow the court to fix your punishment?
Yes, sir.
You understand that any future convictions that you have will enhance the range of penalties?
Sir.
Is that your signature on the document?
It is.
I'll accept the agreement order pre-sentence investigation report to be done and schedule the hearing for September the 5th. Oh, sir, okay, let me get the correct date.
I'm not sure, it's next Thursday, so I don't.
Can the PSI be done by next Thursday?
Judge, I doubt it can be done by next Thursday.
Second. September the 12th. Since it's September the 12th. Now, Ms. Gordon Anderson or someone in the Commonwealth Attorney, these weapons bother me a little bit. Mr. Stockton?
That's Mr. Hunley, Miss Anderson's case. They've been killed.
Yeah, I'll just tell you up front that these weapons bother me. Was this a home robbery or what?
The owner of the home was deceased. So he just recently passed away. His home, these guns were taken. As part of the plea deal, Mr. Southworth was to have the guns brought back to the sheriff's
I
office.
heard what
Five of the 6 were returned. Not in good condition.
well, I'll take a look at it, but stealing from a dead man and then taking guns out kind of goes beyond the pale to me. I don't think this gentleman can afford to take this to the jury, quite frankly. So, we'll take a look at it. Okay, thank you.
Thank you, Your Honor.
Yeah,
Your Honor, may we be excused?
yeah, absolutely.
But the same.
Got Mr. Morland ready now?
Yes, Your Honor, my apologies. Ben. You can put it here.
Daniel Morland, 08 CR 0079 and 08CR 0078. Are you Daniel Morland?
Yes, Your Honor.
Born in 1987.
Yes, sir.
Last four digits, social security 9809. Here today to enter pleas, is that correct?
Yes, Judge.
Are you currently under the influence of drugs or alcohol, sir?
No, Your Honor.
Okay, is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that we just identified in 08CR 0079 and 0CR 0078?
Yes, Your Honor.
Is your judgment impaired today in any way?
Yes, Your Honor.
Is your judgment not impaired? Impaired means you know, you don't know what's going on. You
Oh,
don't know
yeah,
what's going on.
yeah.
It's not a word we use very often, but have you discussed these charges with your attorney and are you satisfied with his advice?
Yes, Your Honor.
Have you reviewed the evidence Commonwealth has against you? You believe you're fully informed about your case?
Yes, Your Honor.
You understand that you do not have to enter a guilty plea, though you have certain rights under Kentucky and the United States Constitution before I can accept the plea. I need to know that you understand those rights.
Yes, Your Honor.
Now, I'm gonna go over them here, and at the end, I'm gonna ask if you understand. Okay? You're right, I testify against yourself, no one can say anything right to speed trial, but jury, from the counsel at your jury trial, right to confront and prosecute all witnesses, call to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter higher court if you lose, your right to call a Commonwealth, prove beyond reasonable doubt that you are guilty of the charge against you. Understand by entering guilty plea that you give up that right, you understand? Now, I consider Commonwealth's recommendation of applying guns essential for that law. I don't have to accept the recommendation prior to accepting the recommendation. I must have a pre-sentence investigation report and probation and parole. Isn't that correct? That we're going to do that?
Yes.
In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea of guilty and proceed to trial. Will someone come up and tell me what the Commonwealth's recommendation is? You step to the left, sir, there. Mr. Stockton, what is the Commonwealth?
Your Honor, in case number 08-2008 CR 78, he'll plead guilty to sexual abuse, first degree, 2 counts, receive a sentence of 5 years on each count, run concurrently for a total of 5 years. In 08 CR 78 on the charge of rape first is amended, he'll receive a sentence of 15 years. The 5-year and the 15-year sentence shall run concurrently for a total of 15 years to serve. And also in 08 CR 79, he'll plead guilty to charge of sexual abuse first degree and receive a sentence of 5 years to serve. All 3 of those sentences shall run concurrently for a total of 15 years. Have no contact with the victim. The Commonwealth opposes probation or shock probation. He'll receive credit for 13 years, 4 months, and 16 days as the day of the plea. Pay court costs at discretion of the court.
Is that what you agree to?
Yes, Your Honor.
Okay, are you pleading guilty because you did commit the act charged in the indictment?
Yes, Your Honor.
Okay. You're doing so of your own free will.
Yes, Your
Know
Honor.
your constitutional rights to explain still your desire to give up those rights and allow the court to fix your punishment with the range committed by law.
Yes, Your Honor.
You understand that by entering guilty plea today, any future convictions will be enhanced. Is that your signature on the document?
Yes, Your Honor.
I'll accept the agreement. Now, will there have to be 2 reports done in this, a sexual offender and
Yes, they'll have to do both.
so sentencing will be put out?
60 days.
And Judge, there's an order tendered with the documents that expresses that sentencing will be scheduled for the
October
date.
10th.
And Judge, my question, I guess, now that Mr. Morland has entered a plea and he's awaiting sentences, he wanted me to inquire, would this change his status? You know, currently he's a state inmate, but I think by virtue of this plea, he wouldn't be technically into his final sentence in 60 days.
Well, you're
I know-
asking me something that's beyond my scope. I don't work for the Department of Corrections, so
I was just asked to make that.
I don't know the answer to that. You know, they'll decide that up there. It's an administrative thing, and if you want to have any challenge to whether or not he's properly ensconced up there in the state institution, then you can file it there with them. And if they make a decision that's contrary to that, you can bring it back to me for a review, but I don't have any authority to enter an order otherwise.
Certainly, Judge, thank you.
Okay, thank you very much.
Don't have all the paperwork. That's what we pay the back.
Where's the rest of the offer? We have a history of those disappearing sometime.
Here, just take this one. Hey, Melissa, you make us a copy of that so we can have it.
Okay, thank you very much. Commonwealth versus James Abson
Judge, I think he's one of the ones that
being processed, will come back. Commonwealth versus Archie Borkins. He have a district, a district warrant, to the warrant here.
Yes.
See, I was still looking to do that. Where is this downstairs?
Frankie here. She checked out back there.
No, he's on the pass.
Oh,
Oh, James Abson.
yeah, he's down, he's gone down to the jail.
See, what I wanted to do is do their stuff here and then take them.
He's already gone to the jail.
We'll have to bring them back up here.
We'll bring him.
Okay.
On the Archie Boyd thing, the jail gave him for September the 5th of 9 a.m. on his farm.
Judge, I think our DPA represented Mr. Boykin at the lower level, so assuming that would continue, I would just ask, given what Madam Clerk said, not at his fault, he was given the,
Mr. Stockton, you hearing this?
I am.
See him here on September the 5th. Why did the jail do that?
They don't have a problem with Warren and so they're trying to they thought too soon to today.
Jordan Bridgeman. Commonwealth versus Jordan Bridgman, 24 CR 0056. Are you Jordan Bridgman? Yes. You born in 1997? Yes. Last four digits, social security number 0614. Yes. We're here for a pretrial conference. What does the Commonwealth have to say?
Your Honor, I have,
Mr. You just step to the left there, sir.
Mr. Cross, and I met on this case negotiation day. He gave me some information. I'm having Sheriff Martin follow up on.
What is the charge?
It's theft of property. And there's some issues involved, and some more investigation done to see if I have a case or not.
Okay, you want to take it out till
September 5th, and we can meet on September the 3rd at 1.
September the 3rd at what time?
1 o'clock.
Here?
Yes, Your Honor.
September the 3rd.
It would be all that separate.
1 o'clock here is, and that's part of, you hear September 3rd, 1 o'clock, and your next court date is September the 5th at 9 a.m. Both of them part of your bond, okay? Okay. You can go. Gail Brown. Gail Brown. Commonwealth versus Gail Brown, 24 CR 0045. Are you Gail Brown? Sir. Okay. Born in 1973. Last four digits, social security number 6063. Yes, sir. We're here for a pretrial conference. What do we have?
Mr. Brown. Is intention to enter a plea?
Judge, I'd like to get someone to explain what I'm signing. I've asked questions and
You,
Wait,
Judge, there's-
wait a second. You're the special prosecutor.
yes, Judge.
And Mr. Brown, your attorney, and Mr. Brown, you get behind the podium here. Do you understand what's going on here? You act a little disjointed or that you don't understand because your attorney says that he's gone over this with you. Do you understand what I'm saying to you?
yes, sir.
Okay. Now, has he gone over it to you, with you? Are you gonna enter a plea or you want me to set a trial date?
Could I ask a question? Your Honor,
Well, sure.
there's parts in here that I don't understand. That's all I'm asking.
Well, what do you not understand?
Judge, there's provisions that are.
Let him tell me what you don't understand.
Okay.
Okay, in one part of it, in all regards, Your Honor, it says registered as a sex offender. My,
Judge, it does not say that. It says if the first first two letters, if the defendant is entering a guilty plea to any offense under, and it proceeds to list several
And he's
statutes that he's not entering a
So
plea
it
to.
doesn't apply to you.
I've explained that, I've read
Well, I'll
that.
just explain to him again.
Okay, thank you.
Okay, is there anything else?
There's one more question, Your Honor, with all regards. I'm in trouble by myself. I made my bad
Tell me
choice.
what your question
My
is.
question is, it says I testify against the co-defendant. There is no co-defendant.
So again, Judge, I explained, there's no co-defendant.
Okay, now
It's standard language.
It's in the language. Okay, so now is there anything else?
No, Your Honor.
Okay, can we proceed?
Yes, sir.
Okay. Now, a motion has been tendered that says you wish to enter guilty plea. Are you currently under the influence of drugs or alcohol?
No, sir.
Okay, is this freely and voluntarily given? Okay. Now, we previously identified you as being the individual that's indicted in 24 CR 0045. Is that you?
Yes, sir.
Okay. Is your judgment impaired today in any way?
No, sir.
Okay, have you had plenty of time to discuss this matter with your attorney, and are you satisfied with his advice?
Yes, sir.
Okay. You believe that you had an opportunity to review all the evidence the Commonwealth has?
Yes, sir.
Okay. You understand that you don't have to enter guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a guilty plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by a jury. The right to be represented at your trial by counsel. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in favor. Have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand, but entering a guilty plea, they do give up all those rights. You understand that? And I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept it. Prior to accepting any recommendation, I will order a pre-sentence investigation report about probation and parole. And in the event after reviewing that, if I don't accept the Commonwealth's recommendation and decide to give you a harsher punishment, I'll allow you to withdraw your plea. Okay? If you step to the left, Mr. Commonwealth Attorney, what is the Commonwealth's recommendation?
Judge, on a plea of guilty to the charges in the indictment, the Commonwealth recommends a sentence of 6 years on count 1, 3 years on count 2, 12 months on count 3, and 7 days on count 4, all to run concurrent for 6 years to serve. Commonwealth recommends the sentence be probated with supervision for a period of 5 years.
Okay? Back up. Is that what you agreed to, sir? Is that what you agreed to? You heard what he just said. Is that what you agreed to?
Yes, sir.
Okay. Now, are you pleading guilty because you did commit the acts in the indictment as amended? Okay. Now, you're doing so of your own free will. Okay. Now, I know your constitutional rights have explained to you, it's still your desire to give up those rights. Enter plea and allow me to fix the punishment according to law.
Sir.
Can you understand it? But entering this guilty plea, if you have future convictions, they could enhance the range of penalty on persistent felony offender law. You understand that? Okay, is that your signature on the document? Okay, I'll accept an agreement, order a pre-sentence investigation report. You'll remain free on your same bond. And you need a probation and parole officer will want to interview you so we can get the report ready. You come back here for sentencing on September the 5th.
Judge, if I may very briefly, count 4 to the amended indictment was a DUI. We wanted to cover those.
Okay. Thank you for bringing that to my attention. DUI is enhanceable too. If you have another DUI sometime in the future, it could be more serious penalty. You understand that? Okay. Now, do we have all the DUI papers and all that stuff?
Judge, that was not prepared with the Commonwealth, so Mr. Brown will have to enter a separate form that the clerks have.
What's the total court cost? Is it DUI first? I don't
It
know.
is DUI first.
$1,115. Now, at sentencing, if you don't have the money to pay that right away, I'll give you some time to make payments on that, okay? So, Okay, so go over there and meet with the probation and parole officer and he'll make an appointment with you to interview. Does that take care of you, sir?
Yes, sir.
Yes, thank you for being here. Have a safe trip home. We need to clear this area out here. The grand jury is going to come back in now. Y'all were just clearing it. Maybe go back in that jury room back there, Mr. Carroll, it'd be comfortable back there.
Am I good?
Where's the entry of guilty plea form?
Did I have both? Um,
Was there a signature on there?
I think it's, the paper bears, it's the offer and a motion.
Yeah, get Matthew, get to come up, Mr. Leverage real quick. Seems like we don't have a full set of documents here.
You don't need the actual motion, or is that in the middle of the motion? Documents.
Typically, we just do it, but
Okay.
I apologize. I didn't recognize local practice. It's my apology.
It's okay.
Thank you.
Thank you so much.
If we need to enter one, that's nothing you would have to sign anymore, so.
Okay, bring the grand jury in.
All rise for the grand jury.
Okay, everyone can be seated. Who's the foreperson of the grand jury? Mr. Bailiff, will you retrieve it? Have 9 or more of your group agreed on everything?
Yes, Your Honor.
Okay. I have to look down at the calendar every once in a while to believe it's August already. I'm confused. Okay, I will make sure that we issue the appropriate either warrant or summons to take care of what you directed the court to do. The next time that you'll be here is September the 5th. Unless you're called back because of riot or insurrection. And these days, you can't ever tell when you're gonna have a big insurrection, where the world is, but you'll be contacted if you need to come in for a special purpose. Other than that, you're excused for the day, and it looks like that you've made minimum wage today. All rise for the entry. Eric Clavel, everybody be seated. Eric Clavel. Is Eric Clavel here?
Yeah.
Commonwealth versus Eric Clavel, 19 CR 0060. Are you Eric Clavel?
Yes,
Born in 1974. Last 4 digits, Social Security 9699. We're here today on a pretrial conference.
Last time I was here, my lawyer, removed himself from my case. I don't have $5,000 more to give somebody else. That's what he took from me and quit. So I'm asking
Who was
for,
your attorney?
Hoover. And I'm asking for a public defender.
Well, what we'll have to do is you have to fill a form out. We'll help you fill it. Yeah, this lady will go back with you and help fill a form out, see if you're eligible. What's, Mr. Stockton, what's the charge on you?
It's a DUI. We had a plea and then Mr. Hoover, the plea wasn't entered, Mr. Hoover withdrew.
Yes.
DUI for.
Luther Connor. Commonwealth versus Luther Connor, 24 CR 0065 and 24 CR 0064. Are you Luther Connor?
Yes, sir.
You born in 2002.
Yes, sir.
Last four digits, social security number 0424.
Yes, sir.
You're here for arraignment. You have a right to remain silent or you're represented by counsel. The grand jury of Clinton County's returned an indictment charging possession of controlled substance of first degree methamphetamine. Possession of controlled substance of first degree methamphetamine, an additional charge. Possession of a handgun by a convicted felon and possession of drug paraphernalia. You understand those charges?
Yes, sir.
You acknowledge the counsel, you acknowledge the identity of your client receiving indictment, away formal reading, arraignment, enter proof not guilty, reserving all pre-trial motions.
Yes, Your Honor, I was just making sure it's for both indictments.
What is the bond in this case? I asked the pre-trial person to take it back.
10,000 cash, 10,000 cash, we got the
Probation.
And he made the bond.
Yes, sir.
My granny made a property bond for me because I've been working and stuff.
Well, you need to be present on September 3rd. You need to be present on September the 3rd for negotiation and back here, that's at 1 o'clock. And back here on September the 5th for your next appearance. Both of those are conditions of your bond. I'm signing a reciprocal discovery order on these cases so the Commonwealth will give you information to help prepare your defense negotiation. You understand those two dates I gave you?
Yes, sir.
Sure. You won't be around any guns, man.
No, sir, I won't.
Okay. See you later.
Thank you, Judge.
Charles Dickin. Commonwealth versus Charles Dickin, 24 CR 0043 and 24 CR 0044. You are Charles Dickin.
Yes.
You were born in 1961.
Correct.
Last four digits, social security number 5978. Okay, we're here on pre-trial conference. What do you have?
Judge, we're just waiting for an amount as far as restitution goes. I would think we would be ready to enter a plea on the 9/5 date. I wouldn't think that Mr. Dickin would be here for the 3rd. Would you?
Yes, I do, because we're gonna have to resolve the restitution.
Well, yeah, okay.
Yeah.
My apologies, Judge.
September the 3rd at 1 o'clock, be here for negotiations, and September the 5th, be back here for your next court hearing if you want to enter a plea, okay?
Yes, Judge, thank you.
Commonwealth versus Kashiba Dickin, is that right? Kachika Dickin. Story, Mr. Stockton.
I don't know, she had a court date, she's not here, looks like. The lady here says she's coming from Ohio, so.
So she didn't make it, so.
Didn't make it on time, evidently.
Issue a bench warrant. For failure to appear. Johnny Duvall.
Probably need to get Tom Carroll out of seclusion.
We could have forgotten him back there, Mr. Stockton. He might have been there for days.
I knew you'd turn up eventually, I mean, I said.
Morning. Commonwealth versus Johnny Duvall, 24 CR 0063. Are you Johnny Duvall?
Sir.
Were you born in 1970?
Yes.
Last four digits of social security number are 2803 You're here today for the purpose of arraignment. You're represented by counsel. You have the right to remain silent. The grand jury of Clinton County's attorney indictment charging you with possession of controlled substance. In the first degree, trafficking in controlled substance in that first degree. Possession of marijuana, possession of drug paraphernalia, possession of a handgun by a convicted felon. Do you understand those charges? Do you understand those charges?
Yes.
Okay. The reason I have to ask you is it's a voice activated microphone and didn't turn the camera. Okay. You acknowledge the identity of your client receiving that in the way formal reading and arraignment enter plea not guilty.
I do, Your Honor,
Reserve
reserve the
all
right to
free
make
time.
motions. Request free trial conference.
Are you gonna be filing motions in this case, Mr. Kerr?
Actually, I have no idea.
I just wondered, I didn't know if we were needing negotiations. Well, that's curious.
Well, we probably do.
Okay.
Mr. Parr is actually one handling the case. He's on vacation.
Okay.
Okay, are you to be here at 1 o'clock on September 3rd for negotiation, and your next court appearance is at 9 a.m. on September 5th, and both of them are conditions of your bond. What is this bond in this case?
Standard curfew.
Do what?
Standard curfew. So that if you bring the road.
$1,500 or what?
Range costs $10,000.
Yeah, that's what I'm asking you.
And that package.
Well, you know you're not to be around any weapons. You understand that?
Yes, sir.
Okay. We'll see you then, the next appearance. Okay, thank you.
September 3rd, September the 5th.
Right. Third is at 1 o'clock, third is at 1 o'clock, the fifth is at 9 o'clock. Gregory Goodman. Brown. Commonwealth versus Gregory Goodman, 24 CR 0060. Are you Gregory Goodman?
Yes, sir.
You were born in 1964. Last four digits of your social security number are 9506.
Yes, sir.
You're here today for the purpose of arraignment. You're represented by counsel. You have the right to remain silent. The grand jury of Clinton County has returned an indictment charging you with leaving the scene of an accident or fail to render assistance, wanton endangerment in the first degree, assault in the second degree, operating a motor vehicle under the influence, failure to maintain insurance, and criminal mischief in the first degree. You understand those charges?
Yes, sir.
Counselor, do you acknowledge the identity of your client, receive the indictment, wait formal reading and arraignment, enter a plea not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, we'll come back here for negotiations. You to be here at 1 o'clock. Justice now on September the 5th for negotiation, and your next court date is at 9 a.m. on September the 5th. September 3rd for negotiation, and September 5th. You understand those conditions involved, Mr. Stein?
He allowed to drive, it's conditionally bond.
You what?
Is he prohibited from driving, it's conditionally bond?
Says in court ain't no problem, but you better check the paperwork and you do that with jail just to make sure.
I'm not driving anyway, so I promise not to.
Here.
I'm going back to up there, go back and about everything from the dumpster and say all for it.
Okay, you need to put no driving on there too. You just acknowledge it in court. Good catch there.
Thank you, Judge.
Okay. Michael Lyans.
Yeah, it's on my desk. That time was.
Commonwealth versus Michael Lyans, 24 CR 0008. Are you Michael Lyans?
Yes, sir.
Were you born in 1960?
Yes, sir.
Last four digits, social security number 3813.
Yes, sir.
You're represented by counsel. You're here for a pretrial conference. What do y'all have to report, Mr. Stockton?
Your Honor, there's another case pending on Mr. Lyons that the sheriff Markham was just out of the plea. It's on my desk. I'd like to get their names, so I would suggest setting this case for September the 5th. And I don't know if that case is going to the grand jury or not.
Well, let me ask you something.
Yeah.
You think it would serve purpose to negotiate on September 3rd and proceed by information if they agree to it, or do you,
So if he wants to, we can do that.
what do you say, Mr.?
I, stop now. We're free to talk about it anytime before then, once you get your review of the file completed.
That's what I'll do, Mr. Cross. Just have him back. He comes from Indiana, is that right?
No, he's here now.
I was here. So
September the 5th at 9 a.m. is your next court date.
Go. I'll be good.
If you ever work with someone else. Rodney Manis. Commonwealth versus Rodney Manis, 22 CR 007. Mr. Manis, were you born in 1970?
Yes, sir.
The last four digits of your social security number 3824.
Yes, sir.
You're up here for review. What's the Commonwealth have to say?
Mr. Manis recently paid $400 to catch him up. Somebody on his behalf paid it. And I'm in a quandary. I would like Mr. Manis to pay regularly, but the only way I can get him to do this is when it comes to court. So I don't know how the court wants to handle it.
How much, what is this restitution?
It's rest-
How much is owed?
He still owes $30,000. I'd say probably $13,000. So I don't know if we want to read it in December.
Judge, I
Or
already
just let it go and file another motion to revoke. But I want Mr. Manis to prove to me he can pay that.
Judge, we have.
Can I speak?
No.
What are you gonna do?
Well, it's, I get paid commission, sometimes that's reading, it's a little different, my pay.
What's your saying?
Yeah,
that's the reason I pay very.
So it's more than that.
And Judge Rodney tells me where he works, he's on commission, so his payments fluctuate. I would ask the court to kind of set this for review and see where he's at.
How much is he supposed to be paying a month?
Same as $300.
Yeah, it's 150.
Okay, well, I'm gonna tell you what, you might be working on commission. If you don't have the $150, I suggest you go to check for cash fast and get the $150.
Okay.
Because, you know, you're taking up our time, you're taking up the efforts for over $150.
Okay, I understand.
So you pay them. I'm gonna put it on for review on December 5th, and if you haven't made timely payments, bring your toothbrush with you. Okay? Okay.
Okay, this year, the public's wanting another thing in each of the contract.
Okay, thank you very much.
Judge,
Jason Murphy. Who is the other co-defendant with Mr. Manis? Is he making payments?
I think he was revoked and went to prison, I believe.
Yeah, okay.
We should try everywhere in the world, but we didn't want to pass where he could, he never could.
Commonwealth versus Jason Murphy, 24 CR 0062. Are you Jason Murphy?
Yes, sir.
Were you born in 1978?
Yes, sir.
Last four digits, social security number 6784.
Yes, sir.
You're here today for the purpose of arraignment. You're represented by counsel. You have the right to remain silent. The grand jury of Clinton County has returned an indictment charging you with trafficking in marijuana, possession of drug paraphernalia. You understand those charges? Counselor, you acknowledge the identity client received the indictment, wait for more reading arraignment and reserve all pretrial motions.
Yes, Your Honor.
You'll be here for negotiation day on September the 3rd. And the next date is September 5th. Both of them conditions you your bond. Okay? Okay.
Thank you.
Wanda Neil.
it's not big.
That's.
Commonwealth versus Wanda Neil, 24 CR 0049. Are you Wanda Neil? You born in 1974. Were you born in 1974? Is the last four digits, social security number 7635. You're on a pretrial conference.
Judge, if I may very briefly, I know when you called the case, Wanda had affirmed that she's Wanda Neil. I believe her current name is Wanda Land, Land.
Without objection, we'll amend the indictment to Wanda Neil Land. Is that okay with you, Mr. Stockton?
Yes, fine, Your Honor. I think we're mad.
Okay. you have anything to announce? Has there been any progress in negotiation on this case?
We're still awaiting some, actually, I believe we received labs maybe a day or two ago
On the DUI.
on the DUI, and we're still awaiting labs on, I think, the tox report. Or I may have that confused, Judge, but we still have some outstanding
Mr.
stuff.
Stockton, when you come around, I can't. Let me move over this way. What's the deal on this?
We've got the DUI lab report. I don't think if this is the right case, and I remember Ms. Vanderpool's checking now, I don't think there will be a lab report on the substance because it's a residue. So we may just have to do a DUI please and dismiss.
Because it was what?
Residue, the officer didn't send it out for a lab. So I won't check and verify that. But if we set this for the 5th and the 3rd, we'll have a
Okay,
resolution.
we here for negotiation day on September the 3rd at 1 o'clock and September the 5th at 9 a.m. is your next court date. Okay?
We'll do it here. The license, it's got, you know, some of that.
Make sure you're here. That's good. Cromwell versus Timmy Parr. You, yes, are you Timmy Parr?
Yes, sir.
You were born in 1970.
Sir.
Last 4 digits of your social security number are 733.
Yeah.
We're on 23 CR 0064 for sentencing. Who is your attorney?
David Cross. He's back there. So.
You knew where he was, you know, to keep an eye on him.
You gotta keep up there.
Mr. Perigin, have you had an opportunity to look at the pre-sentence
Yes,
investigation report
sir.
done?
Yes, sir.
Is it substantially correct?
Yeah.
Mr. Cross, is there any reason not to sentence this, sir?
No, Your Honor, it's appropriate to proceed.
Your opponent get plead guilty, possession of controlled substance, first he shall receive 3 years, probation 5 years. Probation is to be supervised. And defendant shall serve 100 days in jail, shall receive credit for 86 days. He shall serve 60 additional days in in-home incarceration. All of the contraband and paraphernalia will be destroyed. What are the court costs?
155.
100,
155.
160 or 55? 155. I'll give you decent time to pay it 30 days after you get out. You can start paying it at $50 a month, okay?
After I get off the ankle bracelet, or
Do what?
after I get off this, the bracelet, ankle bone.
Well, you're going to jail.
No, he's got.
I already went to jail.
Okay. See, I'm just reading the thing. No, are you working anywhere?
Yeah,
Well,
yeah.
you can start paying it 30 days from today,
Okay, I may just pay it all off.
the way you want to. Commonwealth can live with or without it. The question is, can you? I don't want to put any hardship on you. You know what I mean?
Kind of is, but it's my fault.
Okay. Okay, well, I guess you'll need to meet with the probation parole officer over there.
Thank you.
Thanks very much. Michael Ritchie. Michael Ritchie. What do you feel, how do you feel about his ankle bracelet?
He's not.
Here.
How much time does he like?
You filled out about a month ago on the break. I think he needs to.
Okay. I just want to know how much time he had on. Okay, thank you. Michael Ritchie, not here.
Now we've got, is there an arrest warrant for him?
There is now.
Okay.
He was supposed to be here on arraignment, so I guess do a bit.
Yeah, they can run for September the fifth.
Do what?
The jail they run for September the fifth.
Well, we had a motion to revoke too, so. It doesn't matter.
Who's that?
Michael Rich.
It's out.
That's I don't know how you bond that on a revocation.
We didn't have a holder on it. He bonded out before you
Okay.
placed it.
September the fifth.
That'll be fine.
Maggie Scott.
Scott, take process, Your Honor, on a Cumberland County indictment. I expect further soon.
Sharon Sidwell. Commonwealth of Kentucky versus Sharon Sidwell, 24 CR 0054. Are you Sharon Sidwell?
Yes.
Born in 1970. The last four digits of your social security number 7041. You're here for pretrial conference. What do you have?
Judge, this is similar to Ms. Lyans' case. I think I don't want to say that. I think we're waiting on some labs.
Yeah, will be a lab in this.
Okay.
case.
Okay, so you want to redocket it when?
September the 5th and the 3rd. Yeah.
Okay, well, you'll be here at 1 o'clock, 1 PM on September 3rd for negotiation and at 9 AM on September 5th for your next court date, okay?
Yes.
John Smith.
Your Honor, we have a diversion plea and a DUI plea on Mr. Smith.
Commonwealth versus John Smith. 24 CR 0010. Are you John Smith?
Yes, Your Honor.
Born in 1987.
Yes, Your Honor.
Last four digits social security number 5238.
Yes, Your Honor.
Okay, understand that you filed a motion for enter a plea today on a diversion. Motion's been tendered. It says you wish to enter a plea. Are you currently under the influence of drugs or alcohol?
No, Your Honor.
Is this plea freely and voluntarily given?
Yes, Your Honor.
I've just stated your name and your digits. Are you that same person that is identified
Yes, Your Honor.
in 24 CR 0010? Is your judgment impaired today in any way?
No, Your Honor.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, Your Honor.
Have you viewed the evidence from the Commonwealth that the Commonwealth has against you?
Yes,
You believe you're fully informed about your case?
yes, Your
You
Honor.
understand that you do not have to enter a guilty plea, that you have certain rights under the United States and Kentucky Constitution. Before I can accept the plea of guilty, I need to know that you fully understand those rights.
Yes, sir.
You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury, you have to be represented by counsel at your jury trial. You have a right to confirm and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses to your favor and have process issued for their attendance. You have a right to appeal this matter to higher court if you lose. You have a right to part of the Commonwealth prove on a reasonable doubt that you give any charge against you. Understand that by entering guilty plea, they give up those rights.
Yes, sir.
Understand that? You have to say something.
I said, yes, sir.
Okay. You have, wasn't being rude to you. You just have to speak loud enough to activate the microphone. That camera doesn't come on to you. So.
Yes, yes, Your Honor.
Okay. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. I will ask you some qualifier questions. Have you previously been diverted in the last 5 years?
No, Your Honor.
Have you had any felonies in the past 10 years?
No, Your Honor.
Are you currently on probation? Are you currently on probation?
No, Your Honor.
Okay, now you step aside. Mr. Stockton, come up.
Your Honor, Mr. Smith will plead guilty to operating a motor vehicle while under the influence. First offense, received $200 fine and costs. He also received 2 days in jail. Upon a plea of guilty to wanton endangerment first degree, he will receive a sentence of 3 years, pretrial diverted for 3 years supervised. He'll pay restitution amount of $2,414.22 at the rate of $200 a month to the Clinton Clerk's Office within 30 days, beginning 30 days from the entry of this plea. Restitution subject to the 5% fee. That'll be added to the payment. Once restitution is paid in full, the Commonwealth will agree to dismiss the diversion. He'll receive credit for time served. He'll obtain and maintain gainful employment. All evidence in this case will be destroyed.
Is that what you agreed to?
Yes, Your Honor.
You understand that if you successfully complete the diversion programs, as you said, the charges will be dismissed.
Yes, Your Honor.
And you can have it expunged. You understand if you don't successfully complete the diversion program, it can be brought back before the court and the diversion can be revoked and you can be a convicted felon. in that situation, you could have future crimes or felonies sentences increased under the persistent felony offender law. You also understand that DUI is an enhancement offense. If you get another DUI, it could potentially be more. Do you understand that?
Yes, Your Honor.
Okay, now, are you pleading guilty because you committed acts charged in the amendment, in the indictment as amended? You pleading guilty to the charge, are you pleading guilty because you actually committed the acts charged in the indictment? You did what you're pleading guilty to.
Yes, Your Honor.
As amended, they've amended it down.
Yes, Your Honor.
Okay, you plead guilty of your own free will.
Yes, sir.
And knowing that your constitutional rights have explained it to us, you still your desire to proceed and allow the court to fix your punishment within the range permitted by law. Is that your signature on the documents?
Yes, Your Honor.
Okay, I'll accept the agreement and enter the diversion order. You'll need to meet with the probation and parole officer. What's the court cost to finance?
We're talking $355.
There's a DUI.
It'll be about $1,000.
What you say? $1,115. You need some time to pay that?
Yes, Your Honor.
Okay, you can pay that $75 a month. The first payment is due 30 days from today. With probation.
Send me for you.
Angela Wallace. Angela Wallace.
James, are you representing Joseph Wallace?
Angela Wallace. Commonwealth versus Angela Wallace, 24 CR 005. Are you Angela Wallace?
Yes.
Born in 1972.
Yes, sir.
Last four digits of social security number 7871. You're on a pretrial conference. What do y'all have to say?
Your Honor, I'm trying to get Miss Angela Wallace and Mr. Joseph Wallace on the same court day, and I don't know that Joseph Wallace had counsel yet, because he's getting conflict counsel.
He does not have conflict counsel yet. That was sent to them when he was arraigned last month, and I'm still waiting.
So I don't see you need to have a negotiation, but I've got, once he's got counsel, I want to negotiate the case and settle it, get a trial date.
Well, I'm gonna go ahead and schedule it for negotiation day, and I want you, if by end of midday tomorrow, if your counterparts don't tell me that they have counsel for him, then I'll enter an order directly to do something.
Thank you, Judge.
I mean, it's already been a month. He's entitled to an attorney. It's not your fault.
No, I understand.
But I'm not gonna, they don't need to languish around. They need to face this, okay? So you're gonna schedule them to be there on September the 3rd at 1 p.m. for negotiation. And I want to order that he's to be there with counsel on that day and on September the 5th. Thank you. We'll go back up to Eric Clayber. Mr. Clayber, I have your affidavit that you signed here. Where did your $1,000 a month come from?
Tyson Foods.
You just making $1,000 a month?
It's a part-time job.
Well, do you have any other income?
No,
Well, how do you don't have any, you're not drawing?
I'm a full-time caregiver to my 80-year-old mother who has dementia.
Okay, did you get any reimbursement for that? Okay, well, I'll put you a public advocate then. And earlier, when you were walking out, I guess, Mr. Hoover had previously represented this gentleman. Mr. Stockton said that they thought they had a plea agreement and that it didn't go through. So is there any reason to come back for negotiation?
No.
Okay, so let's just set a trial date.
I'm fine with that, Judge. Since I'm just getting an appointment, I'll need a little time.
I understand that, but I just didn't want you to go.
No, I agree.
Futility, you know what I mean? Are there any labs or anything on this, Mr. Stockton?
We should have everybody, Your Honor.
As old as the case is, we need a little time too, make sure we get our witnesses served.
Okay. let's look out at, look at the 10th and 11th of next month. We have
trial.
Harbor and Parrish in here. Is it going, Mr. Stockton?
I approach. I've been diligently working.
Boy,
I don't want this out.
well, you don't need to say it right here. Okay. Let's go off the record just for a second. I know. Someone distracted her.
We can hear you now, Your Honor.
Okay? Barron County, are you on there? Barron County Detention Center? Commonwealth versus Nicholas Holland, and they're not, Barron County's not on. Okay, Boyle County, are you on? Okay, Marion County is not on. Russell County. Let's go to Wayne County. They just have a couple of people. Let me do Wayne County real quick. You turn your microphone on. Commonwealth versus John Brown. Are you John Brown?
Yes, Your Honor.
You born in 1979. The last four, Social Security number 2532.
Yes, Your Honor.
You're here on sentencing on 23 CR 0059. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes.
Counselor, is it substantially correct?
Judge, there's just one clerical error we noted or found. The plea was to possession of methamphetamine only. The TSI reflects that it's a possession of methamphetamine and fentanyl. The lab resulted no fentanyl, and I think the Commonwealth may have done an oral amendment to the plea paperwork, so I think that might be the confusion, but aside from that, there's no errors.
What do you tell me that the plea agreement says it's fentanyl and it shouldn't say that? Is that what you're?
That's the PSI says that it was fentanyl.
But does the plea agreement say fentanyl?
No,
So it needs to be changed to what?
just possession of.
Two counts or one?
One count.
Just one count of
Correct.
possession of meth.
Correct.
Okay.
The Commonwealth agree with that?
Yes.
Is there any other changes? If
No,
not,
Your Honor.
on plea of guilty to possession of controlled substance, first degree, one count, the defendant shall receive a sentence of 1 year to run for a total of 1 year. What are the court costs?
155.
155, and then the defendant shall be given, pay that at $35 a month. 30 days after he's released from jail. Now, is he serving some other charge?
Judge, he has a holder out of Wayne County.
Okay. Well, probation and parole will go over there and take a look at him over there. He's presently on somebody's schedule.
He's taking time to serve, so he'll be a state inmate.
He get paid, he just get, he paid when he gets out. Okay,
Thank you, Judge.
thank you. Thomas Tucker. Commonwealth versus Thomas Tucker. 24 CR 0034. Are you Thomas Tucker?
I am, Your Honor.
You born in 1986?
Yes, sir.
Last four digits, social security number 8482.
Yes, sir, Your Honor.
Okay, this is a pretrial conference here in 24 CR 0034 and a motion for release of records. What do we have here?
And Judge, that's actually my motion. We have a good faith basis to believe that one of the complaining victims in this case, Miss Naomi Tucker, has given conflicting or impeachable testimony in the Wayne County juvenile case between the two parties. With it being Wayne County, do believe a court order would be warranted to get access to those videos of that record.
What's the Commonwealth have to say?
Well, this is a domestic violence case. I'm sure there'll be inconsistent statements.
So, I mean, what do you say about the order?
Well, I think Mr. Pennington's entitled to it, and I want a copy of it too.
Absolutely.
So we can watch.
Okay, you want to, let's submit an order, we'll electronically file it. And then besides that, will you want a negotiation day in this case?
Judge, once I review that, I want to see, I mean, again, I'm flying blind because I don't know what I have a good faith basis to believe what it's going to say, so.
Well, that's, I'll schedule it for negotiation day. And if you're not ready to negotiate, you can just send an agreed order.
Yes, Judge.
September the 3rd at 1 p.m. for negotiation and September the 5th.
I'll tender that order.
I don't know whether you could hear that, what was going on, Mr. Tucker, but we entered an order.
Yes, sir.
Right, and your attorney will be over to see you, okay?
Yes, sir, Your Honor. Thank you.
County, do we have anybody else over there?
No.
Thank you very much for your cooperation. You're excused. Russell County, now we'll go to Russell County. Thank you. Commonwealth versus Tommy Clayber.
I'm here, Tommy Clayber.
Okay, you're Tommy Clayber?
Yes, sir, I am, Your Honor.
You're on 24 CR 0057. Were you born in 1974, Mr. Clayber?
Yes, sir.
Last four digits, social security number 0040.
Yes, sir.
What do we have? What's the Commonwealth have? You gonna come around, Mr. Sykes?
Yes, we only got the lab back on July the 29th, so that was past our last negotiation day, so if we can set it for September.
Okay, a negotiation day at 1 p.m. on September the 3rd. And the next court appearance will be at 9 a.m. on September 5th, both of them conditions. Now, why is he being held on this case or something else?
Judge, I believe he was a state inmate, or I think that's about to change, or.
Yeah, 9th September.
I can check.
Got 9/9.
Okay,
So he'll still be a state prisoner when the
Yes.
negotiation day, so you'll need to do a transportation order.
So, Your Honor, I get 10 days back coming today or tomorrow, so it'll be August the 30th is when I should be done with my state sentence.
well, Tommy, if you get out, you need to make sure you're back here on September the 3rd.
He's
at 1
got a
p.m.
bond. If he gets
Okay.
out from there, he's got a bond. What's the bond?
Yeah.
My computer problems.
I think it's 15,000 surety.
$15,000 surety with the same stay-at-home orders, and that's the curfew orders and things. So if he can make the bond, if he gets released over there, you have to make a bond. And the bond dates, so the jail and everybody will know, are September the 3rd for negotiation and September 5th in court. Both of those will be conditions of bond, okay?
Yes, Judge.
Thank you very much.
Yes, sir, thank
Ashley Duvall. Ashley Duvall.
Yes, hello.
You Ashley Duvall.
Yes,
You're on 24 CR 0048 and 23 CR 0049. Were you born in 1987?
yes, 87.
Last four digits, social security number 4575.
Yes,
You're here today on pre-trial conference and probation resolution. What does the Commonwealth have to say? Mr. Stockton?
We have a felony plea,
Okay.
Actually, just pre-trial for those in reversion. It is.
You're correct. Well, we had probated in there, but it's diversion.
Well,
If we couldn't have.
she's on probation. How can she do a pre-trial diversion?
It's a misdemeanor, portion on probation. That's the reason.
You got the statute there.
I don't have it handy. I'm positive misdemeanors that go figure out diversion.
I kind of thought they did. I don't know.
Oh, being on misdemeanor probation?
Yeah, I think it just says probation is what the statute.
Oh,
I've wondered about that. You know what I mean?
you can change it to a felony.
Well, is the statute, what's the statute now?
KRS 533.30 subsection 1. 533.30. I think those were new books delivered recently.
They're using frequently.
Oh, sorry, I was just looking at section in the, yeah.
Oh, that's just.
Oh,
It's
sorry.
533,250.
Okay.
You got it? What does it say? Well,
Well,
I'm just on the, if it's probation, they're on probation.
it just says that there's nothing about misdemeanors in the statute.
533.
It says it can within 10 years immediately preceding the commission of this offense be convicted of a felony
Or.
or have not been on probation or parole or released from the service of any felony sentence.
That was a question because they had it, whether it was a disjunctive or conjunctive or at one time, so I'll take it, it's okay.
Okay.
So are you currently under the influence of drugs or alcohol? I mean,
No, no, sir.
so you wish to enter a version plea today?
Yes,
Okay. Are you the same person that we just identified a few minutes ago?
yes,
Actually,
yes,
have you discussed this matter with your attorney and are you satisfied with his advice?
yes,
Have you reviewed the evidence the Commonwealth has against you and are you satisfied that you are fully informed about your case?
yes,
Do you believe, do you understand that you do not have to enter a guilty plea today? You have certain rights under Kentucky and the United States Constitution. I'm going to go over those rights with you. And then ask, you understand? Okay? You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose. Require the Commonwealth to prove beyond a reasonable doubt you're guilty of charges against you. Understand that by entering a guilty plea today, you give up those rights. You understand that?
yes,
Now, I may consider the Commonwealth's recommendation, but I may apply a range of sentence without the law. I don't have to accept the recommendation. In the event that I accept the recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea and proceed to trial. Do you understand that?
yes,
I'm going to ask a qualifying question here. Have you previously been converted in the last 5 years?
yes.
No,
I mean,
you haven't.
what- no, I haven't.
Haven't had a pretrial diversion in the last
No,
5
no,
years.
no, no,
You
no,
have felonies in the last 10 years.
no.
Now, you're
So-
not currently on felony probation, but you're on a district court misdemeanor probation, correct?
Yes,
I hear circuit courts.
Well, it's a
Yes,
misdemeanor. Misdemeanor. You understand if you fully complete the diversion agreement, the charges will be dismissed. Is that correct?
yes,
And you understand if you do not successfully complete the diversion, probably be brought back in a pre-sentence investigation report done. You'll be sentenced to be a convicted felon that can be used against you in the future. Do you understand that?
yes.
Shocking, you want to come up? Go ahead.
Your Honor, Miss Duvall will plead guilty of one endangerment first degree, 2 counts. She'll receive a sentence of 2.5 years on each charge run consecutively for a total of 5 years. She'll be pretrial diverted for 5 years, supervised. Upon a plea of guilty to DUI first aggravated circumstances, she'll serve a sentence of 7 days in jail and pay a $200 fine. She'll receive jail credit for 66 days and she'll be released on August 8th I think that's incorrect because I don't think she's gonna be oriented until tomorrow, so it'd actually be 67 days. Yeah, when we did this plea, I thought Mr. Cross was gonna orient her today, but he's changed the date out until tomorrow. She agrees to enroll and complete the Clinton County Specialty Program, pay fine, pay court costs discretion of the court, obtain and maintain gainful employment, all evidence in this case to be destroyed.
You also understand, is that what you agreed to?
Yes.
You also understand there's a DUI plea, so that can be enhanced if you get another DUI. Do you understand that?
Yes.
Okay, are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes.
One of the constitutional rights, as I've explained to you, is that your desire to give up those rights and enter a guilty plea under charges and allow the court to fix your punishment within the range permitted by law. Is that correct?
Yes.
Okay, is that your signature on there, ma'am?
Yes, that's my signature. That's my signature.
I will accept the plea agreement, sign order. And as you heard, they're gonna be over for an orientation, not today, but tomorrow.
Okay, thank you.
Gonna do it over there, or is she gonna be released? We will be released tomorrow. When we find out the time that the orientation will happen, we'll include that in the order. Okay,
She's been released at 7. It's on the order, I think.
in the order, I think you'd be released in the morning at 7. You come straight over and follow the order about your orientation, okay?
Okay, thank you, Your Honor.
What's the court cost?
Courthouse being right at $1,115.
$1,115 issue of court costs and fines. You'll need some time to pay that.
Yes, I definitely do.
You start paying it 30 days from tomorrow and pay $60 a month, okay?
Okay.
Okay, thank you very much. Now, I guess we need Jamie Scott next. Jamie Scott. Are you Jamie Scott?
Yes, sir.
You're a 21 CR 0026 probation revocation. You born in 1995, Ms. Scott?
Yes.
You need to speak into the telephone, okay? Were you born in 1995?
Yes.
You need to speak up, man. We have a heart, with last 4 digits, social security number 9033.
Yes.
You have a probation revocation hearing here. What will time will come up?
Yeah, sure.
And Ms. Scott claims.
Yeah, she had a 3-year sentence on the trafficking. She tested positive for meth. Go to treatment and then I'm stopped.
Okay, she's stipulating, is that correct?
Yes, Judge.
And we'll go ahead and impose the sentence. Okay?
Thank you, Judge.
Thank you very much, Ms. Scott. I hope things turn around for you.
Thank
you.
Lara Stinson. Ms. Scott, Lara Stinson.
Yes, sir.
Yeah.
Did I gave Ms. Scott him out. Fine. Laura Stinson. For sentencing in 23 CR 0016, you are Laura Stinson.
Yes, sir.
Okay, we're here for sentencing. Were you born in 1987?
Yes, sir.
The last 4 digits of your social security number, 4704, is that correct?
Yes, sir.
Have you had an opportunity to look at the police investigation report done by probation and parole? Is it substantially correct?
Yes.
Counselor, is there any reason this lady should not be sentenced today?
No, Your Honor.
On a plea of guilty, of theft but deception, she shall receive 1 year to serve. What are the court costs involved? Court costs are imposed at $155. 30 days after your release, you can start paying that at $30 a month, okay?
Yes, sir.
Okay, thank you very much. Do we have anybody else there in Russell County? Y'all got anybody else for us?
Not that I know of, Your Honor.
Okay, thank you. You are excused.
All right, thank you.
Okay, let's go. Let's go back. We have Barron or Boyle County, either one on there. Barron County, will you come on? Mr. Lee Davis, I see that you're on there also.
Yes, sir, I am.
Commonwealth versus Nicholas Holland, 23 CR 0041. 24 CR 0041. Pretty call conference.
And Your Honor, this is a Monroe County case and we're taking a plea.
Yes, Your Honor, we have a felony plea in this case.
Mr. Holland, can you hear me okay? There.
Yes, sir.
Okay. A motion's been tendered that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Do what?
Is this freely and voluntarily given? You're doing this of your own free will, correct?
Yes.
Okay. Now, we previously identified you by year of birth and last four digits of the social security number. Are you the same person named in indictment 23 CR 0041?
Yes, sir.
Okay, is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? You believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I know that you understand those rights. You have a right not to testify against yourself. No one can make you stand. You have a right to speedy trial by jury. You have to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter to higher court if you lose. And the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. You understand that by entering guilty plea today, you give up all those rights. Do you understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. I do not have to accept the recommendation. Prior to accepting the recommendation, I will await a pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation, after having reviewed that report and decided to impose a harsher sentence, you'll have the right to withdraw your plea and proceed to trial. You understand that?
Yes, sir.
Ms. Gordon Anderson, what is Commonwealth's offer?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine in case number 23 CR 41, the defendant shall receive a sentence of 3 years. Upon a plea of guilty to burglary second degree in case number 24 CR 41, the defendant shall receive a sentence of 5 years. These two sentences are to run concurrently for a total of 5 years, probated for 5 years. Probation is to be supervised. The defendant agrees to testify truthfully against co-defendant Aaron Southworth in Monroe Circuit Court. The defendant agrees to pay restitution in the amount of $6,000 to Julianna Hedrick at a rate of blank per month. First payment being due on the first day of September 2024 and due on the first day each month thereafter until paid in full. The defendant shall pay court costs at the discretion of court. Defendant shall obtain gainful employment or do a minimum of 30 hours per week of community service until gainful employment is obtained, and shall have any and all contraband and controlled substances in the above style case to be disposed of in a manner consistent with the laws of the Commonwealth of Kentucky and the holding agency. We extended this plea offer prior to Mr. Southworth entering his plea, and before we knew that Mr. Southworth was
That's
going.
okay. It really doesn't change.
Well, the restitution amount is going to change because prior to Mr. Southworth's turning the guns over, the restitution amount was going to be $6,000, and now it's been reduced to $2,750, which is what we would want Mr. Holland to also pay instead of the $6,000.
I'd say that'd be all right with you.
I don't think.
Yeah.
And two, obviously, since Mr. Southworth has entered a plea, and if the court does accept Mr. Southworth's plea, we won't
You just need to interlineate that on the orders, especially as the amount. I believe the testimony what it is.
Okay, thank you.
Interlineate it and have the council to initial it. You understand, Mr. Davis?
Yes, sir.
Now, sir, is that your understanding of the Commonwealth's offer?
Yes, sir.
Are you pleading guilty of your own free will because you are guilty and for no other reason?
Yes, sir.
You know your constitutional rights is still your desire to proceed and allow the court to fix your punishment.
Yes, sir.
You understand that after this plea, any future convictions could be enhanced as far as the range of penalty provided. You understand that?
Yes, sir.
Mr. Davis, do you have a copy of the plea agreement with you there?
I do, sir.
You hold it up to the camera, and let him identify his signature.
Your Honor, I have it electronically. I'm not able to hold it up at this time.
Will we sign it electronically? We've got one here. Miss Gordon Anderson is
Thank you, Your Honor.
provided to the court here. Is that your signature on there, sir?
Yes, sir.
Okay. Okay, I'll accept the plea agreement. Schedule pre-sentence investigation report to be done by probation and parole, and the date in Monroe County will be September 12th for sentencing. Okay.
Yes, sir.
Okay, Barron County, thank you for your cooperation.
Your Honor, we would ask if his bond he's being held, I believe, in 24 CR 41 with a $25,000 cash. The Commonwealth has just offered him probation. He's got over $2,000 in restitution to be making. He needs to be out and start working and start making payments. We would ask that the court
Well,
unsecured.
is the bond cash?
It is, Your Honor.
Why don't he pay the restitution out of the bond and I'll let him out for sentencing?
Well, Your Honor, he didn't post the bond is $25,000 cash. He has
Okay,
not.
it was the bond was on this case and he wasn't able to make it, is what you're saying.
Well, there's two cases. His first case was surety, which was posted surety 15,000, and in 24 CR 41, it's 25,000 cash. You can't post that, Your Honor. We would ask that he unsecure that bond so he can start working now and start making payments on his restitution.
Sorry, Your Honor.
He's being held on the motion to revoke.
Okay,
Okay, and now this one is a plea.
yes.
They're wanting to get him out after the plea, but you got a motion to revoke on the other charge. What are you gonna do with the other charge?
I don't know about that.
Well, this would be moved to patient. So we got them both. Yeah.
Yeah, so we're not gonna be planning on revoking him, Your Honor.
You want him to stay in jail until sentencing?
Are you y'all negotiated bills?
No, Your Honor. He doesn't have to stay.
Well, he'll have to make a bond. Bond is $15,000 clerk approved surety. If he can make a $15,000 clerk approved surety, I'll let him out on the bond until sentencing, okay?
Yes, sir.
Judge,
Thank you, Your Honor.
he is released.
Wait just a second.
If he's released, he needs to contact the Dare County Probation and Parole as soon as he's released to complete a PSI.
You understand that, Mr. Holland? If you make the bond, you need to immediately contact.
Not a Dare, Barron County.
What's my bond? What was it?
$15,000 surety bond.
I won't be able to make that. I've got nobody.
It doesn't take any money to make it. It's a clerk approved surety. Somebody just come in and sign the bond.
So I can just have my mama come up to the,
You have somebody, your mama, your great aunt, your cousin, a friend, anybody comes up and the clerk approves surety bond can sign your bond, okay?
And
Get
Your
you out,
Honor,
and as a condition, when you get out, you need to go to
It'll be on the bond paperwork.
Yeah, where you go to Glasgow? You do go to the Glasgow probation parole office to fill out your pre-sentence investigation report. If you don't make the bond, they'll come see you in jail to do it, okay?
Yeah, 'cause I won't be able
Okay, and Your Honor, that's in 24 CR 41 where it's 25,000 cash now, and that will be changed.
I've changed it.
Yes, thank you, sir.
$10,000 assured. Okay?
Thank you, Your Honor. May we be excused, sir?
Yes, thank you. Barron County, you may be excused. Thank you very much.
Thank you.
In Boyle County, we've never gotten on there, correct? Somebody check with Boyle County.
That Harold,
Yeah.
He's got for pro, shop it, 18, so it's on his face.
Judge, I don't know if we're gonna be able to get on anyway, but I'm fine with passing that motion. Mr. Harold actually comes up for parole September 18th, so
Okay, well,
that was my intentions
So
today.
you could redoct it for October the 10th then. And if he's already out, we no reason to do it. October 10th, continue to October 10th.
Yes, yes.
Clinton County Jail.
I'm sure we'll have him here and have him do it right.
I think he.
Clinton County Jail, I say.
I'm calling Judge.
They're on there, they just don't have their stuff turned on.
And this part's in probation, probably need you all in court, man. We're ready for you. All right.
They're the ones who dressed in previously.
You'd have to really, you know, your own policies.
It's gonna be where it is. Douglas Penicuff, you come around.
Go ahead, where's Keith at? Hey, who do you want first?
Douglas Penicuff, 24 CR 0067. Are you Douglas Penicuff?
Yes, I am.
You born in 1957?
Yeah, I am.
Last 4 digits of social security number 050.
Yes, sir.
Here for the purpose of arraignment, you represent by counsel, you have the right to consile. The grand jury of Clinton County charged you with possession of controlled substance, first degree murder, for offense, and falsely reporting the incident. Do you understand those charges?
Yes, sir.
You acknowledge the identity of your client, received and out in the way, formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Come back here for negotiation at 1 p.m. on September the 3rd. And on September 5th, you'll be back at 9 a.m. Those
Yeah.
are both conditions your bond. Your attorney will come in and meet with the Commonwealth on September the 3rd and negotiate your case.
Yeah.
And if you reach an agreement, you come back on September the 5th to take care of it. Or if you don't, you come back on September 5th, we'll set your trial. Okay?
Okay, I'll spend him 1 minute after, do I need to keep my patch on?
I have nothing to do with that. So I'd say you do.
So. If you don't, I ask you about-
Judge, it was, I think it was a bond condition out of district.
Yeah, it was.
take it off and,
Okay.
is
Thank
that
you,
all
sir.
right?
Yeah,
Get in the shower and take it off. Enjoy
no,
it.
I gotta call her, she gotta do it,
Okay.
so. Yeah.
No, it's mine. I'll see you on the third. Thank you.
Who else? Maggie Scott. Commonwealth versus Maggie Scott. 24 CR 0053. Are you Maggie Scott? Born in 1984. Last four digits, social security number 3307. Represented by Mr. Cross at pre-trial conference. Will the Commonwealth come forward? What do you have to say?
Well, I guess, Mr. Cross representing both families, I agree. So we need to, I guess, set her for the fifth and the third and try to resolve those cases from the county.
And Your Honor, she's just been served with the Cumberland that. And so if we could get her, she's been processed, if we could get her to stay out on the same bond, but I can put the bond is, she's not
Good. Yeah, there was $100 cash bond on the warrant, and down to this money.
Will we have a copy of the indictment from over there?
It's a $15,000.
It's a possession.
I'm just saying, if we got a copy of the indictment, we just go ahead and arraign her here. Call over there to the clerk's office, see if they'll send you a copy of the indictment.
Want the case transferred over here?
Here you got somebody, well, I'm not gonna transfer the case over here, I'll just indict her here. I'm just gonna arraign her here, if y'all decide for purposes that you want to combine the cases or transfer, we can later. Okay, who else do we have?
James Abson, Judge.
James Abson.
Yeah, he was processed on I guess a district court, FTJ. I think he's been resolved.
Commonwealth versus James Abson, 24 CR 0050. We're here for the purpose of arraignment. Mr. Abson, were you born in 1974? Yes, sir. Last four digits, your social security number 9964. Here for arraignment.
Yes, Judge.
You get arraigned. Mr. Abson, you copy of that.
10 years.
Yeah.
She deserves it every day.
You have a right to remain silent. You are represented by counsel. Grand jury county's returning indictment charging you with possession of controlled substance, first degree methamphetamine, possession of drug paraphernalia. You understand those charges, bailiff? Counselor, you acknowledge the identity of the client proceeding that will wait formal reading and arraignment, interfere not guilty, serving all pretrial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order requires the Commonwealth to provide information on client defense. He shall be here on September the 3rd at 1 p.m. for negotiation and September 5th at 9 a.m. for his next court date. Ready?
Yes, Your Honor. One other quick matter, similar to Mr. Penicuff, James has on a district or patch from a district court bond.
What is it costing him money to have a patch on there?
I believe so, Judge. It's a fee associated with like a home incarceration. Oh, he's got well, you want to keep that on, I believe. And it's probably a bond issue. I think he's got a ankle monitor and a patch on.
District court.
Well, I think based on Mr. Penicuff's previous history, he had 4 possession convictions. Mr. Abson's got a lengthy criminal history involving drug abuse. I think the patch was probably warranted in both cases itself. That's just my opinion.
Well, I didn't catch that opinion earlier.
No, I just studied.
Oh, well, Judge, I apologize. This is county pay.
Okay, let's leave it on there.
That's first go charge I've ever had.
Well,
Okay, thank you.
thank you, Judge.
Should have another one too, but that's okay.
Yeah.
Okay, are we back down to the Clinton County Jail? Clinton County Jail. Turn your radio on.
Yes, sir.
And Billy Brown.
Billy Brown.
Something's in front of your camera there, the jail. Something's laying in front of your camera.
He's getting Billy Brown right now.
It's obscured. Either that or you're having an eclipse. One of the other.
Yeah, definitely.
Partial eclipse.
That was one. Sign. Right.
Something in front of your computer. Is there?
Right here, Your Honor.
It's what? There you go. There you
Okay,
go.
sorry, Your Honor.
Okay, now if we can get to Billy Brown. Commonwealth versus Billy Brown. 22 CR 00020. Are you Billy Brown?
Yes, sir.
Were you born in 1968?
Yes, sir.
What are the last 4 digits of your social security number?
9932.
You're here on a pretrial diversion revocation. What does the Commonwealth have to say?
Your Honor, this is a case, he has a 3-year sentence on possession of controlled substance, first degree, pretrial diversion. He has 2 positive tests for meth, with 1 being diluted, and he denied use, and Mr. Payne had both of them allowed, confirmed his methamphetamine were prepared for hearing.
And Judge, if I may just inquire Mr. Brown very briefly, Billy, I know we had spoke earlier, or
Yes, sir.
it's your intention to go to rehabilitation. Is that still what you're wanting to do?
Yes.
I'd ask that at this point in time, Your Honor, Mr. Brown completed drug court. And this screening started after he completed drug court. We want to take him off supervision, but because of these positive tests, I'm here for revocation. I think probably it would be revoked, and if the court wants to send him to rehab, we can. As much time and effort as Commonwealth of Kentucky's put in this case.
Yeah, and they get the dilution thing that bothers me too. I'm not.
And Judge,
I'm not feeling it.
well, I understand, Judge. I guess it's important to know, you only got half the story here. In specialty court, Mr. Brown is on a medication that in specialty court had similar test results. It was clear through specialty court at that time that this was a result of some medication he was taking. Now, I'm not a doctor. I don't claim to have medical license.
You testify like one in court.
I try, Judge, but I'm skeptical. I just want to make note of that, and I know that doesn't.
I don't have any of that in front of me. Now, if you want to schedule a hearing on that and present some proof, we can do that.
Judge, I think at this point, we're at pretrial or diversion revocation,
Well, he's
so.
entitled to present evidence if he should not be revoked. It's a decision I have to make predicated on the allegation. If you want to call any kind of witnesses to show that he's got some drug, that this was a false testing, it wasn't diluted, you can do all those things. We've got plenty of time. As long as you prepare for that previous DUI case I scheduled. The rest of your time can be spent on this.
Judge, I would ask to be permitted to reserve and make those arguments upon sentencing.
We'll sentence him and we'll look at these things on shock probation or on probation.
Yes, Judge.
Okay, I'll order a pre-sentence investigation report be done and we'll have the sentencing on September the 5th. Okay.
I'll be over to speak to you, Mr. Brown.
Thank you.
Frankie Davidson.
See Frankie Davidson again.
Frankie Davis?
Como versus Frankie Davidson. Mr. Davidson, you step back just a little bit so we can see your head. There you go, buddy. Como versus Frankie Davidson, 24 CR 0038. Are you Frankie Davidson?
Yes, sir.
You born in 1980?
Yes, sir.
Last four digits of social security number 2243.
Yes, sir.
We're here on a pretrial conference. What do we have in this case?
Judge, we're close. I think we actually have a resolution. I was late getting some paperwork, both myself and to Mr. Davidson. If we could.
Is this going to be a plea with a possible probation, Mr. Stockton?
No, it's time, sir.
Time to serve, so just depends on who's pays for the time.
Your Honor, we got the papers back down here and he did sign them, is what Pennington's talking about.
Have they been sent back?
No, we got them right now. Let me send them back to you.
They can bring them up here. This is just down the street here. Okay, if you'll send somebody up here with the papers, we'll call him back in just a minute, okay?
I'll be out there, Your Honor.
Mr. Davidson, we'll call you right back in a minute when they get the papers up here, all right?
Sit him back just one second. I'm going to the house. Call somebody else too. They're going to call somebody else after it.
Ferdinand Gerger.
Ferdinand Gerger.
Ferdinand Gerger.
Okay, we're getting, Your Honor.
Billy Brown, that. You can see. I just now. He just, if you make sure it's fine.
No,
Somebody else's name. Put him back in.
I think it is something like, he did it with us. I think the county did.
Ferdinand Gerger.
Yes, hello.
Okay, this is 21 CR 0090. Mr. Gerger, were you born in 1958?
Yes, I was.
Last four digits, social security number 5474. We're
Yes,
here.
sir.
We're here today on a probation revocation and a pre-trial diversion revocation. What does the Commonwealth have to say?
Your Honor, this is the case where he's got a 5-year sentence on possession. We were gonna have a hearing to revoke his supervision, diversion. We agreed to put him in the PSAP program, the lockdown program. The first time he did admit he had a drug problem. So we sent him back. They evaluated him this time and they said he doesn't qualify for health risk.
Yes.
Now, Mr. Payne can explain to you, he's working on an alternative placement if it's all right for us.
All right, so I'm
Get
working,
behind the microphone there.
I'm working with 2 SSCs and it's a share program. It is a mental health slash substance abuse program. He'll get help for both and he'll be able to get the medical help he needs there. We're working, there's a wait list, so we're waiting on that. And it's not at a lockdown facility, but it's at a treatment center that we send people to all the time. It's going to the Hope, it'll be at the Hope Center in Lexington is where it should be, unless they end up having to place him at another center, but they're a waiting list right now. So, in lieu of revocation.
And Judge, I have no objection to that. I've actually worked with the Hope Center up in my neck of the woods, great program, and I hope to get Ferdinand the help he needs.
So you want Mr. Stockton, what you're telling me is you want to pass this until it's said we get him in the roll?
He'll stay incarcerated until he can be transferred to that facility. I'll agree to that because he does need it.
Okay. We're gonna try to find Mr. Gerger. I guess you heard they're gonna try to find a facility, get you some help. So then we're gonna proceed with the pre-trial diversion revocation or the probation revocation. Try to get you help and pass it. And if you get in good shape, probably, get to proceed with your life, okay? Thank you very much. Brian Gross.
Your Honor, I'll be right back with you.
Brian Gross.
Brian Gross. Hold on a second.
So it should.
Hey, Judge, just an update on Ferdinand. He is number 8 on the wait list.
I don't know how long it takes if you're number 3, 4, but I'd rather be 8 than 9. So. Brian Gross. Okay, Brian Gross and Christopher Hughes on deck, okay? Commonwealth versus Brian Gross, 24 CR 0031, 24 CR 0041, 24 CR 0058. Are you Brian Gross?
Yes, sir.
Born in 1985. You born in 1985. Mr. Gross, can you hear me?
Yes.
Were you born in 1985?
Yes, sir.
The last 4 digits of social security number 2218.
Yes, sir.
We're here, what we got here?
Judge, I guess I'll kind of take the lead on this. I actually have a motion on particularly the 24 CR.
What is that ringing? Is there something ringing in the background? That's what's keying the mic there. If you'll answer the phone or turn it off, unplug it. Thank you. Okay, proceed.
Judge, I'm speaking on 24 CR 41. It's the felon in possession of a firearm case.
Can you hear what's going on here, Mr. Gross?
I can't hear. I think you guys got
It's not, the problem is not here. That microphone's the same here. The problem is down there. Okay, Mr. Gross, can you hear now?
Yes, sir.
Okay, now go ahead, speak up loud.
Certainly, Judge. So it's my understanding that Mr. Gross currently does not have a bond on 24 CR 41. I'll default to Ms. Smith on that. Judge, that's the crux of my motion is I understand the nature of the 3 charges, but he currently been held without a bond.
What is that charge?
Possession of a handgun by convicted felon. And this is related to the Michael Lyons case that we passed earlier. I've got a case where Mr. Lyons shot Barry Owens, and I just now got a statement from Mr. Owens. Now, Mr. Cross's position is that he needed to be shot. But irregardless of that, Mr. Gross was in the vehicle with a gun that Lyons used to shoot Mr. Owens. And Mr. Gross has a felony, receiving stolen property out of Breathitt County in 2013. And he has a manslaughter second conviction out of same Breathitt County in 2005. So he's a person that shouldn't be around any guns, even if a person needs to be shot.
And Judge, I believe
That was a car.
I know we're not, Brian, don't say anything. Judge, I know we're not litigating the case today, but this is a
I'm
control.
not even litigating the bond today. I want to know what we're doing on these charges, and then if it's not resolved, I'll set a bond. Let me hear you on that.
Judge, we just received, there's 3 cases. I just received
Mr.
final
Scott,
discovery on the most
give me an
recent.
overview. This gentleman is representing the defendant, and he's got things he wants to talk about. I understand it, but give me like an overview of what we're doing here on Mr. Gross, rather than.
He's got-
the people.
He's got in 24 CR 31, he's got a possession case with 1.166 grams of meth. 24 CR 58, he's got another possession case, but it's meth residue.
And then 24 CR 41 is the case where he was a passenger in the vehicle with Michael Lyons that contained the handgun. I ain't saying he had the handgun on him, but he was charged with constructive possession because he was in the vehicle.
Okay.
So that's what we
Now,
are.
do you want to schedule this for negotiation? What do you want to do?
Well, Judge, we
I just came.
yes, but I would also like a bond from.
I'm going to deal with the bond in a minute if you'll let me get through this thing and we restructure it and then we'll go in the process rather than putting the cart before the horse.
So,
Okay?
yes, Your Honor, we would like, I think now that we have all the discovery in and all the labs, we're in a position to in good
Okay, well,
faith
you
negotiate.
you be over there, have him at 1 p.m. On September the 3rd. My next court appearance would be at 9 a.m. on September the 5th. Now, Mr. Stockton, what do you say about the bond, or do we need to come on up here?
He's entitled to a bond.
Yeah.
And I'll tell the court, I'll be frank with the court. It's not a real strong case of him being in possession of a gun because I'm sure Mr. Lyons' gun, he was a passenger in the vehicle, but he doesn't need to be around any guns and he doesn't need to be
I'll
around
set a
anybody shooting.
$15,000 surety bond.
Yeah.
$15,000 surety bond, okay?
That's what I was gonna say. There's 3 cases and
Who was the lady that just left?
I'd say that's Aggie Young, who's been emailing me about the case too.
Is she happy or unhappy?
She's unhappy. I would be happy with the $15,000 surety bond in this case, but
Yeah, well, what's her involvement in the case?
she is Mr. Gross's girlfriend, and she's been emailing me about how he's gonna go to rehab and stuff, and I need to deal with Mr. Penny, so I need to do.
Okay. So that was his co-counsel, was your co-counsel.
Okay.
paralegal.
Yeah.
$15,000 surety bond, clerk
You
approved,
just want to say that he needed to be
with
shot.
curfew, okay? So I'm changing your bond to 15,000. Anybody can come in with clerk approved surety. Show.
Can this be a blanket bond that will cover all 3 charges?
Wait just a second. Yeah, hey, y'all quiet now. Okay.
He has a $15,000 surety bond posted under 24 CR.
Okay, well, that'll apply to all the cases. Okay,
Thank you, Judge.
Thank you, sir.
okay. Christopher Hughes.
Let's send the paperwork down in 2 minutes.
Christopher Hughes.
Who you need next, Your Honor?
Christopher Hughes.
Yes, sir. Christopher Hughes.
He was the one I said was on deck. Maybe
Yes, sir, he is.
hard that you're familiar with. Commonwealth versus Christopher Hughes, 24 CR 0047. Are you Christopher Hughes?
Yes, sir.
Were you born in 1979?
Yes, sir.
Last 4 digits of your social security number 3125.
Yes, sir.
Okay.
Judge, we just need another negotiating and pre-trial
Mr.
date.
Stockton, are you interested in what's going on in
Yeah,
this
I'm
case?
listening.
Come on up here and tell me about it.
This is the case where Mr. Hughes had 7 grams of meth and 0.2 grams of fentanyl in his possession. He was driving DUI, so.
If you want another negotiation day,
That's, I think we've got the labs there. I'll give him one more, and if we can't resolve it, we'll have to set a trial.
September the 3rd at 1 p.m. for negotiations, September the 5th. That's the 4th day at 9 a.m. So you got the results back?
Yes.
What, positive for both?
Yeah. The only thing, yeah, we've got we've got the DUI, he had fentanyl and meth in his system. And then he had 7 grams of meth in his vehicle along with 0.2 grams. So it all matches.
Okay. Okay, I just want to know. Okay, thank you very much. Let's see, what's this? Okay, your attorney will be over to talk to you, Mr. Hughes.
Yes, sir.
Wesley Reigns. Wesley Reigns. Commonwealth versus Wesley Reigns, 21 CR 0038. 21 CR 0065, 22 CR 0066, and then for arraignment, 24 CR 0059. Are you Wesley Reigns?
Yes, sir.
You born in 2001?
Yes, sir.
Last four digits of your social security number are 6433. Is that correct?
Yes, sir.
Represented by counsel here, Mr. Cross. You're here for the purpose of arraignment. You have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with possession of a firearm by a convicted felon, illegal taking of a turkey or a wild animal of some sort, resident hunting, trapping without a license, hunting without a hunter education course completion card, entry upon the land to shoot an animal or a fish, and persistent felony offender. You understand those charges?
Yes, sir.
Mr. Cross, you acknowledge the identity of your client, received indictments, waive formal reading and arraignment, enter plea of not guilty.
Yes, Your Honor.
Reserving all pretrial motions. September 3rd for negotiation day, September 5th for the next court date. I will hold in abeyance anything on the revocations. So you understand the revocations are being held in abeyance, and then new charge, you'll negotiate all of them together. Okay?
Wesley, I'll be down to see you, but it'll be next week, okay?
Okay. All right.
William Stearns.
She's going to send me a call.
Mr. Stearns, will you step back away just a minute so we can see your head? This is 24 CR 0033. Are you William Stearns?
Yes, sir.
You Stearns was born in 1976.
Yes, sir.
Last four digits, your social security number 1641.
Yes, sir.
You're here today for return of indictment. You have a right to remain silent. You're charged with failure to comply with sex offender registry.
Yes, sir.
Okay. You understand that charge? Understand what it is? I'm not asking if you did or not. You understand what the charge is?
Yes, sir.
Okay. You acknowledge the identity of your client, counsel, received indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Schedule is for September the 3rd and for negotiation at noon and September the 5th.
Judge, if I could be heard briefly on.
Okay, wait a second. Hello?
Yeah.
Okay. Go ahead. Mr. Stockton, come up and get involved in this conversation.
Judge, and obviously this is my first time seeing the indictment, but I was provided with Mr. Stearns a documentation showing that on April 24th, 2024, that he had actually complied with Kentucky sex offender registration form.
That's what was trying to confirm.
Judge, I do believe, and I would need help verifying this, but in the period from December 21st, 2023 through March 3rd, 2024, I believe Mr. Stearns was incarcerated during that period of time. So I think he could have registered, but and a lot of this information, Judge, and I know it's typical to ask for a bond hearing. I would just ask for a little relief from Mr. Stearns, given that he may not be guilty of these charges in the indictment.
That's true of everybody that comes in front of me. They may not. As a matter of fact, they're presumed not to.
Just a second, and I can pull up his last register.
You know, he wasn't registered when he was indicted.
And I'll concede that point now that I've seen the dates in the indictment.
He did not become confined by a law of search.
Yes.
But he was not confined, and then that one was approved to March 9.
Well, y'all can talk about this on the negotiation day.
Yes, Your Honor.
September the 3rd for negotiation at 1 p.m. and September 5th, if you need him to be transported, you need to send an order.
Yes,
The
Judge.
attorney will be over to talk to you, Mr. Stearns. Thank you. Now, do we have anybody, what did we do?
We skipped over Mr. Davidson.
Frankie Davidson. Okay, we're back with Frankie Davidson. Do we have those forms up here?
We do, I have them in my hand.
Is this a felony plea?
It is, Your Honor.
Mr. Davidson, they've got your forms up here now. A motion's been tendered that says you wish to enter a guilty plea. Is that correct?
Yes, Your Honor.
Are you currently under the influence of drugs or alcohol?
No, Your Honor.
Is this plea freely and voluntarily given?
Yes, it is, Your Honor.
Okay, you're previously were recognized as having a birth year of 1980 and last four digits social security number 2243. Is that correct?
Yes, Your Honor.
Is your judgment impaired in any way today?
No, it is not.
You discussed this matter with your attorney and are you satisfied with his advice?
Yes, I am.
Have you reviewed the evidence the Commonwealth has against you? Do you believe you're fully informed about your case?
Yes, I am.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. I want to make sure that you understand those rights. I'm going to go down through them. At the end, I'm going to ask you if you understand them, okay?
Okay.
You have a right not to testify against yourself. No one can make you say anything. The right to have a speedy trial by jury, the right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence, the right to call witnesses in your favor. The right to appeal this matter to a higher court. If you lose, and the right to require the Commonwealth will be on a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea today, you give up those rights. You understand that?
Yes, sir.
And I may consider the Commonwealth's recommendation, but I may apply the range of sentence allowed in the law. I don't have to accept the recommendation. Prior to accepting the recommendation, I'll await a pre-sentence investigation report to be done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and determine to be a harsher sentence, you'll have the right to withdraw your plea and proceed to trial. You understand that?
Yes, sir.
Mr. Stockton, if you'll come forward and tell us what the offer is.
Your Honor, Mr. Davidson will plead guilty to possession of controlled substance, first degree, methamphetamine, receive a sentence of 1 year to serve. He'll also plead guilty to possession of a firearm by convicted felon, 1 year to serve. They would run concurrently for a total of one. After this case there was a traffic stop. Mr. Davidson had meth residue in his car. He also had a .22 rifle in the passenger seat. Pulled the officer.
Is that what you understood to be the offer?
Yes, Your Honor.
Are you pleading guilty because you did commit the act charged in the indictment?
Yes, Your Honor.
You do so of your own free will?
Yes, Your Honor.
One of your constitutional rights have explained to you that still your desire to give up these rights and plead guilty and allow the court to fix your punishment. That your desire to give up your rights?
Yes, Your Honor. So I'm sorry, you broke up.
Give me a signature. That's your signature on there?
Yes, Your Honor.
Good. I'll accept the plea and order pre-sentence investigation report to be done with probation and parole due to the sentencing on September the 5th. And I'm asking probation and parole, when you do the interview, I want you to go into detail I thought it was a good idea as a convicted felon to have a rifle in the front seat.
Okay.
I'm a little skeptical.
I want that, I'm opposed to probation and shot probation. Also, I forgot to say that.
Okay.
And also, I got two copies of the Commonwealth Law with the other, and those with me.
They faxed me back 6 documents I sent home. They brought me back 2 years.
Okay, your attorney will be that back down to talk to you.
Thank you, Your Honor.
Do we have anybody else in jail? Is that complete?
I had some jail docket, we got the lady that didn't show up. Oh, yeah, mine was there. Yeah.
I don't think unless we had going on there. Just one of their stuff, you're right.
So he's not on there.
I mean, I see him on this docket, but the first docket I got, he was.
We filed a motion for competency, but the doctor's not available anyway, he'll be here, we'll say it,
Where is Maggie Scott? She's behind my screen here. What are we doing with Maggie now?
I thought we set her for the fifth and third. Oh, right.
Yeah, do we have a copy though of the indictment here? Come around. Let's do Maggie Scott. Does this have anything to do with Maggie Scott?
Well, this is basically following right for her.
Okay, what did you say?
You mentioned her name that was on the docket, but then it wasn't.
I didn't mention this. I don't know.
Yes.
Commonwealth versus Maggie Scott, Cumberland Circuit Court, 24 CR 0056. These are indictments that have just been warrants have been served on Miss Scott when she appeared in court today. And so I'm going to go ahead and arraign her on these here. Are you representing on this court here?
Yes, Your Honor.
You have no objection to her arraignment?
No, I would,
Commonwealth versus Maggie Scott. Ms. Scott, you've previously been identified, last 4 digits, social security number 3307, correct? The grand jury of Cumberland County charge you with possession of controlled substance, methamphetamine in possession. Okay, y'all are keying the mic, please. Possession of drug paraphernalia, operating a motor vehicle under the influence. Possession of controlled substance in the 3rd degree. Possession of controlled substance not in its original container. And careless driving. Yeah, you acknowledge the receipt of the indictment, the identity of your client, wait formal reading arraignment, you're pleaded not guilty or reserving all pretrial motion.
yes, Your Honor.
Now, would you like to, you want to just let it go before you decide whether you're gonna move the case over here, so we'll set her for a date over in Cumberland County. What's your negotiation date for Cumberland County? It's the same as it is here, you have a.
No, it'll be September the 13th at 9 o'clock.
Okay, well, let's have her negotiate both of them over here. On September the 5th. And then when's the next court date?
The September 19th.
The court appearance over there is September 19th, unless you move to transfer it over here for a joint plea of some part on the 5th.
Still, you can pay when you get to the office. We'll still have 2 weeks.
Oh, that's right, I was thinking, you're talking about the Cumberland County case?
Yeah, the Cumberland County case, keep it in August.
Yeah, she's.
What is August date?
29.
Yeah. At first, yeah, it was September. Cumberland Day.
Yes, but it'd be August.
Give it August.
What do you have?
Well, I don't really see any reason for her to go to Cumberland County then if she's gonna negotiate these things on September 30th at the same time. So let's go ahead and do this. September.
I guess probably that you might have some motions filed as well.
Yeah, Your Honor, could have a sweet plea agreement.
Can we review her bond here and see? I know she made
What is the bond?
Cumberland County's 50,000 surety. She made a $20,000 surety on the claim.
We'll allow that $20,000 to stand for appearances in both cases.
Now, I have a question. You're looking it up, and I have a vested interest in this. There's $1,500 cash posted over there. Has that been released? Or is that?
That's part of the question.
I think it was 15,000, maybe posted percent. I don't know. It's,
It's neither here nor there.
well, she's, both cases are.
Thank you very
Are
much.
are you saying that $1,500 can be released?
I'm not saying that.
Well,
And
what,
that is how much swing by.
they reduced that to 1,500.
Okay.
Okay, thank y'all.
Is the cash still posted?
Thank y'all.
I don't agree.
Thank you. You can go now.
Oh, you got $100 too.
Yeah, I have a card, I have $100 bond that I have to pay,
Oh, that's, yeah.
District Court.
yeah, so
Thank y'all.
we'll do that.
Hey, is there anyone else to come before this?
Shakisha Dickin was not here when she called and the lady said she was coming from Ohio. Is she here now?
Yeah, no, I gotta go at 9:43, it'll be done to Rick on the W, 9:40.
Well, I'd ask for a rescue.
Should be, you tell her just to go straight to jail. Try herself in. Okay, that concludes the business of Clinton Circuit Court, 1 o'clock.
No.
It's off the record.
Motion.
Anything else?
Okay.
Okay. Child support docket. Cabinet versus Duvall.
That's the Joy Duvall case, Your Honor. This person's been arrested. He's got his photograph in the paper, so I suppose we better continue this one.
Till next rule day or what? How much is he owe?
Looks like almost 7,500, Your Honor.
What's he in jail for?
It's major stuff, I think.
Is it major doo-doo? Is it drugs?
Yeah, I think. They said it may be a while before he's out.
He was called in district court. I was working some in district court and we had a child case and we noted that he'd been arrested. So, I noted he.
Well, you know, if he owes that much, let's just continue it.
Judge, he's charged with pleading or evading police, disorderly conduct, reckless driving, pleading, evading police, more than danger to 1, 2, 3, 4 counts of danger of a minor, 1, 2 counts of existing arrest, as hearing schedule of 13 hours.
Okay. Thank you.
Okay, let's continue this till September the 5th.
Got it.
And make sure I'd probably make sure I serve him to get him there. And at some juncture where the arrearage is reaching this level, it might be time for referral. Okay. Cabinet versus Farrell.
Have an agreed order, is that correct?
Gray versus Gray.
We're asking, Your Honor, for continuance as the person made a payment recently.
Cabinet versus Harvey.
I don't know if they're present. You may come forward. You can be heard here. Are you Kathleen Harvey?
Yes.
You understand the child support office is got a balance. They're asking for payment. They're asking for $700 by September 4th, 2024. They show an arrearage balance of $16,200.19. The last payment you made was July 5th, 2024, $50.
Yes.
You have.
Where are the children located?
Florida. There's just one.
One child. This is out of state enforcement.
Yes, Your Honor.
How old is the child?
He'll be 14 in September.
He's living with his father, or his grandparents.
As far as I know, because I haven't talked to him since November of 2018, because I don't have an address or a phone number, because his dad won't.
He's living with his father.
Yeah, in Florida. As far as I know, his father.
How much is this is just an arrearage thing. How much is she supposed to be paying a month normally?
It is basically current support and
What
arrears.
is the current support a month?
$249.46, am I correct, per month? And the arrearage has been $24 arrearage payment,
The bridge has been what?
$24 a month.
Total $24 a month?
It's because she's paying current. They'll keep it low because it's in addition to the current support.
Yeah, why aren't you paying current?
I pay when I can. I have 2 children at home with me. Last year I was pregnant. I've been on cash assistance and enrolled full-time as a college student. And I was paying whenever I can, and I'm still paying whenever I can. I currently re-signed up for my cash assistance.
What is cash assistance?
Through, K-TAP through the welfare office and everything. And I'll be, getting that in September. And it's, I think, 500 and something a month I'll be getting.
for that.
Where are you working now?
I'm not, like,
Why aren't you working?
well, like I said, I was pregnant last year. Before that,
A
I
lot of
was,
people, a lot of pregnant people work.
I was on cash
And
assistance.
a lot of people work instead of going back to school
Yeah,
until they get to afford to go back to school.
well, when I was on cash assistance, you have to do so many hours.
You
And
could
that's what
get
I
a-
was
you
going to
could-
school.
You could get a job.
That's why I
I'm
was going
worried
to
about,
school.
instead of telling me how you're gonna get cash assistance and not have a job. I was gonna be fairly sympathetic to hear your story. But it seems like to me that you're not contributing much to society, that you wanna take things off.
Well, I'm
You're
trying
healthy.
to, like I
You're
said, I'm going to
healthy.
school.
That doesn't pay the bill. Okay, what's your order that you want?
We want to order that she purge herself of contempt and paying $700 before September 4th, 2024, and continue making the current supporting arrears payments.
I'll do it, hand it to you. Okay, thank you. Cabinet versus Hutcherson.
If this person's present, he's not present. Okay. Your Honor, in this case, there is an arrears amount of $9,015.54 as of today's date. We're asking for payment of $300 on or before September 4th and continual payment of $92 per month toward
Okay,
arrears.
that's fine. Cabinet versus Kilburn.
Okay. The child court office requested continuance. They're waiting on response from Ohio. I guess on some kind of status up there. Is that correct?
Yes.
Okay. Cabinet versus Purdue. You have a continuance order that you want to give to the sign, or you just going to do it on the docket?
Sweet notes.
Okay. Cabinet versus Purdue.
Agreed order, Your Honor.
Cabinet versus Pickens.
Oh, no service in that, Your Honor. It's in on this.
Cabinet versus Roberts.
An agreed order, Your Honor.
Cabinet versus Schindler.
We're asking for contempt order. Is that person here? Jason, how would you say that last name? Schlesner?
I already said it. You didn't like the way I said it. What's wrong?
I didn't know if he was out in the hall, but you said that I could.
One lady sitting right here, I don't know her name, but that's
Okay.
what's her name?
That's not the person though. This is an out-of-state case, Your Honor, arrears only of $30,207.81. We're asking for payment of $1,000 by September 4th. You know anything about the person?
He's signed up for disability, but I don't know him.
Okay, you don't know the status of that case.
It's the out of state arrears. It's arrears only. No current support, just
Okay.
arrears.
All right.
Cabinet versus Thompson.
We have an agreed order in this case, Your Honor.
Is that include your document?
We have, one case of 18 CI 129 on the docket of Christian McGall versus Nicholas Barber that's not been called. Is anybody here on that case?
I think the attorney was going to join by Zoom.
He's add on here.
Your Honor, I'm on here by Zoom and my client is on here as well. I don't know why it says I'm on mute.
Turn your camera on, please.
Try. Sorry, the camera was covered up. I don't know why that is.
Duvall versus Barber.
Okay. I'll stay around here a little bit.
Okay, I'm getting parts of your head.
Yeah, I don't know why this camera isn't adjusted a little bit. We got new computers and that's the first time we've used those cameras, okay.
What's the comment have said?
Your Honor, as I'm covering from operations, what I understand is that both attorneys were to file brief with the court. And I think the statute that applies is KRS 403.
Tell me what the problem is.
Well, the problem is, we're asking for an increase in support. The current obligation is $148 per month. And we're asking for an increase to $723 per month effective July 1st. The Child Support Office through the county attorney has submitted with their brief 2 worksheets. One worksheet is the mother has maternity leave, that's using partial pay. The other worksheet would show $625.26 using her full-time pay when she's not maternity leave. And so either scenario, there would be an increase from the 148. So either scenario shows an increase.
Now, is that right?
Just had her.
No, I just had her.
Yeah, so she's not pregnant.
Congratulations.
But thank you.
So that is the
For
comment.
not being pregnant or for having a baby? Which one?
How about both?
Yeah.
Now, I would have one other thing to point
She
out.
returned to work?
I turned to work in 8 weeks.
On maternity leave.
I think the other point that's important and is that there is a medical card involved for, I guess now 2 children. Is that, or just on this? Them 2. There's 2 in this case. Okay, so 2. All right.
The newest child is not.
No.
His fathered by someone else, correct?
Correct.
My camera's not on either.
Your Honor, I did. Yes. Your Honor, do you wish for us to, can they hear us?
All right, there you go. Okay, I can see myself now.
Okay.
What do you have to say, Miss Huntley?
Your Honor, we filed a proposed chart as well. We believe she will be making about $18 an hour at Tyson. We think our chart is most reflective of what his child support should be. It also is $180. I'm sorry.
You direct your comments toward the microphone. You're looking down. It's not picking it up very well.
Okay, yes. So our chart has him paying $180.22, which is close to what the current obligation is. And so we would argue that there's not a change. I think you wanted us to do some research and brief on this issue with the timeshare credit and whether it applies based upon the benefits that she receives. I was not able to find anything directly on point as far as case law goes. And I think that
statute itself does not give direction as to what we do in that situation. I know he is supposed to be receiving equal time, and we are just asking for the court to give him, and I know the court always has discretion in setting these things. So we are just asking for the court to give him credit, to apply the timeshare credit. And then we also think since she's going to be returning to work, perhaps she could testify today on the record as to what she'll be earning at Tyson. I think I have requested some records on that to try to see what her income will be when she gets back at Tyson. But he believes it was $18 an hour is what she would be making there.
What are your calculations estimate that he should be paying? At $18 an hour, if she is making $18 an hour, what do you say that he should be paying? Child support wise?
I believe $180.22, and that's applying the $18 an hour and giving him, and giving him credit for his timeshare. Yes.
What do you have to say?
Well, in response, our worksheet or the Commonwealth worksheet shows $625 based upon that wage that she states the mother should be making per month without timeshare being calculated. The statutes that we referred to earlier under 2A says in order to receive a shared parenting time credit, a parent shall maintain care, custody, control over the child for a minimum of 88 days per year, regardless of the age of the child. So the contention is that he's not making the minimum to receive any credit for timeshare.
Well, in your honor, that raises another issue, which I have a motion and affidavit prepared that he'll be signing today. He wants to exercise his timeshare. He wants to be with the children, but they're being withheld from him. So that has been the issue there. But, and she would need to come back to court for relief if she wanted that modified. I mean, the court order stands, he's to be getting equal time. He shows up at the exchange location and she's not there.
Well, the person that needs to be coming to court is not her. It's him. He needs to come to court and ask for a contempt order against her for not complying previously with the court's order. In the absence of him doing that, I see very little merit in his complaint that he's parented these childs more than the minimum amount there. Now, this is something, this whole thing needs to be worked out, in my opinion. When she's had this additional baby, now she's out on maternity leave for that. I really don't know whether she should be given any credit for reduction in child support or increase in child support because she's not working because maternity leave. See what I'm saying? I don't know. Have y'all tried to mediate this thing to see how much child support you'd be willing to pay?
No, we've not.
Well, that's always a good idea.
We would be agreeable to that.
How much is child support on minimum wage? Y'all know that off the top.
For 2 kids, 300.
300. So he's not even paying as much as you pay on minimum wage. So Mrs. Hamill, you know that's not right.
Yes, you're right. But again, this was based on the children being with him for
Well,
a
yeah,
week. And
we're just talking about reaching an accord here, and then they can solve whether she's not in compliance with the court order somewhere else. Now, the Commonwealth wants $700.
yes.
Right. So if you take their numbers and reduce it by half, it would still be $350, which is, barely more than what you pay on minimum wage, right?
Yes.
So you want to step out of the room and talk to is this money going directly to the mother or is this going to the state?
Mother. Yes. Sometimes
these things are recovery for certain expenses that they have. In this case, it's not. So you want some time to talk to your client about that and then get back with the county attorney's office?
I would be happy to. Yes, that would be good.
I mean, unless he wants, I mean, if he wants to fight it on out on this, this 80-something days, which he hasn't done, I don't think he's got much defense if he hadn't done the 80-something days, if he hadn't tried to enforce that.
Yes, Your Honor. I will discuss that with him and get details on the number of days and on the amount he to be
What do you
agreed.
think about that? What do you think about it?
I think he needs to be paying, more than he's paying in the interim.
Well, we're not gonna have a long interim here. We're not gonna be. I mean, what about around 450? What do you think about 400?
Yeah, at least what we're getting, I would agree.
Do what? See, just turn around and turn your camera off and things, see if he'd be willing to pay 450.
Okay.
Never went through it.
It
was just discussion.
That's resolved in five and 40,000 motions. Yeah.
She can't use those.
Right, but we're here strictly on charts.
I'm sharing what you would use back here. It's free on and if the last that's the people. Yeah, I signed by like reviews.
Again, that's a family court. I'm just here as child support. I quit taking sports and tested the Lord's cases with years out. I've been happy since she's.
I think I know. Well, let's stress.
I start completely. There's exactly what I don't see. I guess I'm walking both ways. No sanction.
Your Honor, says that 450 would be a little tough for him, but he could certainly do 350.
Wait a second.
Just takes motions filed.
It's actually not in June.
Why?
The girl was straight, so maybe that's.
This is a continuation of doing something.
You can.
Okay, well, the issue is whether he's entitled to any credit at all if she's on public assistance, right?
Right.
I believe that puts it in the court's discretion because that's why I pointed out the medical card situation.
So, so I could use my discretion if y'all are agreeable to 450, he's agreeable to 450.
You're agreeable to that? Yes.
It could be that we could do the calculation, you wouldn't get anything this time, but you know what I'm saying?
I do, Your Honor, yes.
So is your client willing to say he's willing to do 450?
You understand he could order almost 1,000, so 450 is pretty good in this. Okay. Yes, he'd be yes, Your Honor, he can do that. Thank you.
We'll enter an order of 450, use the court discretion because she receives assistance.
What would be the effective date, Your Honor? This motion was filed back in June.
I'll make it effective July 1.
Okay. Thank you.
If you'll-
On any arrearage, can we just do, say, $50 a month till he gets that caught up? Or you just, he said he'd rather just go, he'll pay it up, he says.
I couldn't hear what you just said.
Take its bottom.
What did you just say?
Okay, I asked if he could pay $50 each month toward the arrearage, but then he just told me no, that he would like to he'll just go ahead and go ahead and pay it all.
450 is effective July 1.
Okay.
Okay, thank you very much.
Thank you. Have a great day.
Thank you, Judge. A slate's long, I have, plain slate. All right.
The DVO docket. DVO docket. Braswell versus Braswell. We've received an agreed order here, transferring this case to Pulaski Family Court. And if there's no objection, nobody appears to object, it appears to be a legitimate agreed order. Enter the order and transfer it. Clerk's order to transfer the file. I know that hurts your feelings, clerk. Be present. Okay, the civil docket is to start at 1:30. It's 5 minutes beforehand. So we'll go off the record. 5 minutes.
Yes, like to see that. Thanks.
Okay, we're going on the record now for the civil docket. 22 CI 0089 Warner versus Stearns.
Good afternoon, Your Honor. This is my motion for the court to, in essence, set a discovery deadline order and to set this case for a trial. This is a land dispute with some sundry other things such as trespass property and damage to the property from trespass. The depositions of the parties have been taken. I have taken a partial deposition of one of the surveyors. I anticipate that any follow-up I need to do with that would be short. I anticipate that Mr. Little would want to depose the surveyor for the plaintiffs. But after that, Judge, I think we would be ready to try this case. I would propose that the court set an
Is this a
order.
prescriptive use case or was there a dedicated highway or what was it?
This is the defendant's claim of prescriptive easement, I believe is what their claim is in this matter. And,
Is it your client? Your client is claiming prescriptive easement?
That'd be one of the elements. These roadways have been in existence a long time. My client purchased the property at court sale. There was no other way of access. The property joins him now simply because he purchased it, but before it would be totally landlocked without these easements. So that could be an element. Are you finished on that?
I would just say I don't entirely agree with that representation of it. And I think that's why we're going to be headed to trial on this, but.
Well, I would say in response, you know, if the parties were able to agree and we can't force them to, that would be better. And I would just say that my client would like to see if we could do that, but
Have you done mediation yet?
We have not done a formal mediation, Your Honor. We have had several discussions, Mr. Little and myself. But Your Honor, my clients are insistent that they believe they are in the right on this, and I don't really think there's any room for
These people
settlement.
going across, is what you're saying.
Basically, and Your Honor, just a little backstory on that. These properties originally came from the same parent tract and then they were split off, but we don't believe, we think the evidence will show that Mr. Little's client's property is not landlocked and that there is no written easement for this property, and we don't think that they have the right of ingress and egress on it.
I would say in response, I'm not talking about the substance, but procedurally, they've not filed a pretrial compliance, so I don't know what their jury instruction is going to look like. I don't know what their witnesses are going to be. I don't know their theories. And I think it's premature.
Last time you and I had a prescriptive easement case, the Supreme Court wrote the instructions.
That's true.
And so those are the instructions you'll get this time, and I don't think you'll like them this time as well as you did last time.
Oh, they were, I think they dovetail mine, to be frank with you, a lot of it. But again, I don't think it's ready to be set for trial.
Well, then you need to get ready. We need to get it ready. That's what he's saying. He wants to get ready to try it. How long will it take you to finish your discovery that you say?
Well, our surveyor said that.
How long? I don't.
I think 90 days.
Too long.
I propose 60, Your Honor.
Okay, well, 60 is acceptable. Let's go out to rule day here on November the 7th. Be here to announce a settlement, or we'll set a jury trial. And you want a jury trial or you want a bench trial?
We've asked for a jury trial, Your Honor.
Okay. We can do that. And we'll be able to get you.
Your Honor, if I could, I'm sorry to interrupt. I currently have a trial set in Wayne Circuit Court on November seventh. However,
Okay, we can go to December 5th.
I could probably get Mr. Garmin to cover here that day for purposes of
Whatever-
setting for a
whatever you
trial.
want to, we'd be glad.
I'd hate to delay it anymore. My folks are antsy to get this done. So
November 7th.
November seventh, we'll make that work.
Be here and, have complied with all the pre-trial orders that we already have jury instructions submitted. Have any law that you expect to give me a summary of what your witnesses are gonna say, and you don't have to exchange this with each other. It's to inform me about how long it's gonna take to have the trial primarily. Okay?
Very well, Your Honor.
And do you want me to order mediation?
Your Honor, I think that would probably just waste everybody's time and money at this point.
That's unfortunate.
I echo what Mr. Little said. I think this would probably be best for everybody if it's settled, but I don't think it's going to.
As my old law professor used to say, we'll let them lay where Jesus planks them. Okay,
I would just say my clients are flexible and settlement.
you represent the reasonable class, is what you're saying.
Well, I grew up with Charlie Stern, so of course I would say that.
Yeah, okay. Thank y'all very much.
Thank you, Your Honor. That's all I have. If I can be
Sure. Cabinet versus Ball.
Mr. Ball, yeah. I represent Mr. Ball, Your Honor.
Is this one at Hoover on this?
I don't know, I filed this modification.
Michael Reigns.
Stay right over here, Mr. Ball.
Cabinet versus Ball, what is this?
Your Honor, this is a motion for modification of time sharing.
Okay, who are they? Identified.
I represent Tony Ball. He's here to my right, and this, I'm assuming, is the respondent, Ms. Ball.
Regina,
Yes,
you have a lawyer?
not this time.
This is the time.
I was only notified. I received the letter in the mail July 17th. I didn't get it till the 20th.
Okay, what are you trying to do here?
Your Honor, this case was originally, there was a divorce decree entered in 2013 in Rockcastle County. Ms. Ball has lived here with the child for several years. My client lives in Rockcastle, but it's actually on the edge of Madison County. And in January, he was forced to take a dependency abuse neglect case on behalf of the child due to some physical abuse. He was granted temporary custody up until the end of the school year, at which time they went back to their regular schedule. He had the child in the summer primarily, and she got the child every other weekend. Now, during the school year, she has the child through the week, and he has 3 weekends per month. While the child was in his custody.
Well, I don't want to hear the entire case here, okay? Was there an agreement as far as this division of time? Or
In
was there a
2013,
previous order?
in 2013,
Was an agreement in 20, well, that was just last year. 2013, wasn't it last year?
that was like 11 years ago when the child was 2013.
2013 instead of 2023.
Yeah, 2013.
I couldn't understand what you were saying. Having a hard time hearing even with this.
So my client has asked for primary physical, residential care. He's asking that the child be enrolled in school. There's a Christian school near his home.
Okay, well, you know, you've gone down a litany of things that you want here, and none of those can be decided without a full hearing. So what we need to do is schedule a full hearing, and you need to lawyer up,
Yes,
and now's the date.
yes.
So what I want you to do is have a lawyer within 2 weeks.
Okay,
Have the lawyer contact Ms. White. They can contact our office to schedule a hearing date.
okay.
Okay,
Since this has been going on, you have signed one contempt order. In fact, you've signed two. He is still not following the custody
well,
orders.
we'll decide all of that.
And nor is he paying, not a
We'll
dollar.
decide all
child
that. We'll decide. You know, I can give compensatory time to compensate him for any time you lost, or I can order payments to be made, or I can say what he did was justified. That's the reason we need to have a full hearing on it.
Yes, sir.
So you get an attorney, contact her within 2 weeks, and Ms. White, you and that attorney, and she's gonna get called office for a scheduled hearing date, okay?
Before you or Mr. Song, just call
For
me.
meeting.
I'll make it. Okay, I will.
Thank you, Your Honor.
Okay, thank you all.
Thank you.
Asset Security Consulting LSC versus WW.
Good morning, Your Honor, or good afternoon. This is Kevin Hoskins on behalf of WW.
Good afternoon, Judge. Chris Caffey on behalf of Asset Security Consulting.
Okay, what do you all have here?
Your Honor, when we were here a couple of months ago to ask the court's approval for a transfer of certain structured settlement payments from WW to my client, you asked WW to secure an attorney to go through this deal with him so that you were comfortable that he understood the legal and financial implications of this proposed transfer. And so WW hired Mr. Hoskins to represent him.
Mr. Yarling, Attorney Yarling, will you turn your camera off if you're not involved in this case, and then we'll get you, you're being recorded. Thank you. Go ahead. Go ahead.
So anyway, so Mr. Hoskins was retained by WW to go through this transaction with him, discuss any issues.
Mr. Hoskins,
Yes, sir.
you done that?
I have.
And have you explained to your client what a rotten deal this is for him? So
Your Honor, he is only transferring part of the annuity, and frankly, he needs the money.
okay, so you believe he's fully informed about the thing?
Yes, sir.
Okay. And from your conversations, does he appear to have the capacity to make these decisions? He doesn't have any kind of capacity problem or anything?
No capacity problems.
Where is your office located?
I'm in Cincinnati, but our
Yeah.
office is
Mr.
in.
W contact you himself, or was he referred over by the company?
He was referred to me, but we've had several communications.
Mr. WW, all right, so you want to go ahead and proceed with this. What percentage are you, your settlement are you transferring away?
Well, from my understanding, it's gonna be from 2025 to 2048, so that's 23 years. So
what are you transferring away? What are you giving away?
I'm giving away, present value right now is $503,959,979.79 in exchange for a lump sum of $235,619.
So he's transferring all his interest, is that right, in a $500,000 structured settlement? That's what he said.
No, sir. He's going to keep between now and September 2025. He'll continue to get, or he'll receive a $4,000 payment for that month, and then thereafter he'll receive $2,500 per month until September 2048, and after that he will receive a $9,900 payment for the rest of his life. So this is just a portion of the structured settlement.
Okay. Mr. WW, I have no reason to deny or question Mr. Hoskins. I would prefer it if you had found your own attorney somewhere, but I would assume Mr. Hoskins considered himself ethically bound to give you advice, and you believe Mr. Hoskins believes it's his best interest to do this, Mr. Hoskins, is that what you're telling me?
Yes.
Yes, sir.
Okay, well, if you'll electronically file an order, we'll electronically enter it.
All right, great. Thank you, Your Honor.
Thank you.
Mr. WW, it just proves to me that sometimes you can't protect people from themselves. I hope things go well for you. Thank you.
Thank you, Judge.
God bless you all.
Yeah, thanks. Same to you.
If I may say, I had a case on the docket, I don't know if Maggie Scott, it's Dickin versus Dickin.
Well, maybe we'll take it up right after I finish.
No, we resolved it and I wanted to withdraw my motion.
Surely not.
They signed a property agreement.
How
yesterday.
would I have, what would I do with all my time if people reached agreements?
I just didn't want to leave, I forgot.
Okay.
It's not on the docket. Okay, thank you.
Newry's LLC, DPA, Shell Point Mortgage versus Tristan Murphy.
Your Honor, Kibbeney Yarley on behalf of the plaintiff is our
You're
motion
breaking up on us. You're breaking up
her
on us.
motion to dismiss. Sorry about that. Kibbeney Yarley.
I'll sign a motion to dismiss whether I can understand you or not, so. It's okay. Okay, thank you. Thank you. Safe travels, au revoir. Happy trails to you. Okay, is there anything else on the civil docket? You have anything else?
Yes. I had the Samuel Dean Hensley estate for order of distribution. It's on the calendar that I printed out. I filed a motion. It is 23 CI 148.
Give me some background on this.
The court had a master commissioner sale. All the costs and fees have been paid. The commissioner is holding a balance of $38,648.18. I represent the plaintiff, which is administrator of the estate. And the sale took place. It's a mobile home and land. The purchaser has possession now. The monies are going towards debt.
See, it says Medicaid's getting some money, City Albany, Farm America, and then you and her for the cost of administration, funeral expenses. Have you got that broken down?
It's broken down in the petition. We filed a petition. It's with, we broken down. We also had it broke down in the district court action. Nobody's filed an objection except Attorney Lynch, who never filed, or not Attorney Lynch, but Attorney Freeman, who never filed an answer. She wanted to continue it to 2 months. But she did not file an answer. She can, her clients are in default.
It's expensive to die, isn't it?
It is, average funeral now is $10,000. It's, of course, you see it on TV, but I see it in real life. It is expensive.
Yeah. Well, Where's the master commissioner stuff already been paid? Where's that?
There was an order.
I know I'm looking for that order. Master commissioner distribution.
I think it's dated June the 13th, Megan. I didn't bring my entire file. Got the unsigned copy. Did you find it, Your Honor?
Yes. Okay. Have you submitted an order?
Yes, but I have a paper copy one too, if you need.
It's like this.
It should be identical. Thank you, I might get excused.
Yeah, that's fine. Why a Harold versus Storm Resources?
Afternoon,
The lower end of 127 come along, it's all right, and straighten it out, and yeah.
Not yet, it's close.
What do y'all have here?
Judge, I filed a motion for a protective order. I represent the defendants, Storm Resources, Steve Burchett and Storm Burchett individually. Mr. Poindexter represents Mr. Harrell. This case is the result of an explosion which took place at a operation of drilling for oil. Mr. Harrell was seriously injured, extensively injured in that. Mr. Poindexter recently filed a subpoena ducis tecum to obtain financial information of my clients and their spouses. And so that brought about the motion for protective order. One, I don't think it's relevant. It's a negligence claim against them individually and against their company. I understand the broad scope of discovery, as Mr. Poindexter has alluded to in his cases, but the checking account history of my clients, their personal checking account history, has no relation to the claim for damages or to the injuries.
No, it could have in a post-judgment situation if he tried to think that they were.
Absolutely.
You don't deny that if they were trying to hide assets or trying to dissipate their estate.
I don't deny that in a post-judgment situation.
What do you have to say about why this is necessary for you to proceed?
Your Honor, the reason why it's relevant at this time is that there is also a workers' comp claim where they did not have workers' comp insurance.
Are you prosecuting that?
No, I've got another attorney that's handling that part of it.
But not in this case.
No, sir. No, sir. But the attorney paid by the insurance company that's also representing these parties, the same parties, was telling me the other day at a deposition, asked me, well, what about if there's workers' comp coverage, then that's the only remedy that your client would have. Well, during the depositions, one of the defendants testified that he was an unpaid consultant. And then his son testified that he was a paid consultant. At one point, they talked about that they paid.
You lost me on the he's there.
Oh, okay. So it's a father and son.
You're talking about the Burchetts?
Yes, sir.
Okay.
And so the father testified he was an unpaid consultant. The son testified that
dad was a paid consultant. They testified that he was an employee, but then
That Mr. Harold was?
that Mr. Harold was an employee. There was testimony that he was paid by a check, but then Mr. Burchett states that he doesn't have any type of checking account of any kind. And so I think that Steve Burchett, I'm sorry. And so I believe that based on the conflicting testimony, that we need to see bank records to figure out who was paying Dwight Harold and where that money was coming from to establish whether or not he was an employee of one of these corporations or one of the individuals. And I've cited the case law that basically states.
Well, you know, Storm Enterprises or LLC. In one situation, they prove he's a paid consultant and you get to litigate it, or if he was an employee in the workers' comp. Right?
And I'm sorry, say it again.
Oh, I've already said it. Well, so this, the determination of what his employment status, whether he was an independent consultant, was getting paid that way, or whether he was an employee, determines on who gets the better bite of the apple. The bite for him not having workers' comp on it, or just a negligence. Correct?
Right. Yes, sir.
That's determined. Now, how do you suggest, Mr. Who, really be proved? If the father and son, the Burchetts disagree as to what his employment status was.
Then I think, he's seeking financial records in the way of personal checking
Mr.
accounts.
Poindexter,
Mr.
I didn't ask you what he was seeking, I'm asking you how you resolve.
Then I think what he does is he does a request for production of documents, and he can do it from Steve Burchett, Storm Burchett, or Storm Resources.
Well, I would
any
like to
payroll.
hone down your request. I'm gonna let you have some discovery on it. But hone down any compensation, any records that reflect any compensation and what capacity the person was compensated in, that any one of those three parties have.
And we're fine with that. Yeah, we're totally fine with that.
Now, but you feel like that you can't trust or verify that's what you're
That
saying.
is correct, Your Honor. With one of the parties, Steve Burchett, being a convicted felon
Well,
and testifying, well, he testified in the deposition that he didn't have a bank account.
Well, so is one of the presidential candidates. So I don't know this, if there's no more validity to Mr. Burchett's conviction than there was to Mr. Trump's, then I wouldn't give much credence to it. So,
It was a plea,
yeah,
if that helps him.
I've seen people in there badly.
But he testified that he doesn't have any bank accounts. So I wonder if the bank account could be in his wife's name.
Well, then,
Which raises another issue.
well, here's the thing about it, you need to do a request for admission. You need to ask him if his wife has had an account, or if there's ever been anything paid for any of the business out of his wife's account or anybody else's account. There comes to a point in discovery where unless you have a particular knowledge that someone's giving you a fraudulent answer or something like that, that you can't just completely open all discovery. There could be business relationships could be exposed to someone by virtue of bank records. There could be all sorts of things. Now, what could you do to assuage Mr. Poindexter's lack of trust in the candor of your clients? What can you do? Other than withdraw it in case your clients aren't telling the truth?
I think if he sends me a formal request for admissions or production of documents, we will supply that information and we will verify it under oath that it's correct.
And then not only will you do that, but you will have great candor on something else. You know what he's looking for.
I do know what he's looking for.
Okay, and at some juncture, we all have difficult conversations with our clients and say, here's what it is.
Absolutely.
This guy was there doing work. Who was paying? I mean, it's the devil in the deep blue sea. It's the workers' comp claim. And you know, it will cut off certain negligence. That's what workers' comp's for, really, to cut off certain negligent claims where employees are hurt, to give some certainty to companies like that. So at some juncture, there needs to be candor. And people, no matter what they've said up to this point, need to reflect on what they're gonna do. And I think we're at this point.
We are, and I think Mr. Poindexter will acknowledge when I received it, I called him and said, what are you looking for? He told me what he was looking for. The bigger problem I have with the subpoena is it names the counts of both of these gentlemen's spouse, and they're not even parties.
Well, then he's got to ask the question to you.
He does.
And get the spouse under oath to say that there's never been any payment out of any of those accounts. Now, if it gets down to it, if, I don't like to do it, but I can do an in-camera review, to see if there are any entities, if this individual that was hurt has had a check written accounts.
Yes, sir.
So you tell your clients that I'm willing to do that. If they've got anything, they better come with it, and just lay them out there where everybody can see the things and just try to put this thing behind them.
Yes, sir. I'll do that.
And I'm willing to do that if you get to the point where you don't, if you don't see any, I don't really think anybody, are they saying that, who is an unpaid consultant?
Well, the father said that the father was an unpaid consultant.
He's not in the LLC and
Right.
that he just out helping his son and looking around, that sort of, it's just possible.
But the son testified that he pays his father as a consultant.
Yeah, well, I don't know about that.
Which is really irrelevant to the workers' comp issue.
It is irrelevant to the workers' comp issue. If he's paid as a consultant, he's not a principal in the LLC. He's a paid consultant. He wouldn't have any liability on any judgment unless you can prove that he's actually a partner or an owner of this LLC. And to the extent then of their assets, he might have some exposure beyond their assets of the LLC. He wouldn't have. That's the beautiful thing about the LLC.
Yes, sir. But if the father was the one paying Dwight Harold, then it brings into question, was Dwight Harold an employee of the father or of the LLC?
That's true.
So that's why we would the bank records.
And I think if you'll make that specific request, I'll answer it under oath.
Well, you draw an order up and circulate it to Mr. Hoover, and then we'll see if we can get that taken care of.
Okay. Thank you, Judge.
Y'all for being.
Thanks for understanding my party.
Let's go off the record here for a second. I want to ask you about 127. Now, the last budget was supposed to have had the final thing